his right to keep his hair long. They threw it away, handcuffed him to a chair, and shaved him bald.
It's about a Rastafarian.
It is the poster child for a RLUIPA violation, and the law provides a damages remedy. This is spending legislation, so I want to go right to that and make 2 points about clarity and constitutionality. So first, on clarity, the whole point of this law is to restore pre-Smith rights and remedies. Damages were available before Smith. They're available under RFRA, and RLUIPA uses identical language. They're like twins separated at birth. They clearly mean the same thing. The individual capacity action is especially clear. On the face of the statute, it expressly authorizes suit against an official or any other person acting under color of state law. That obviously means individual capacity. And then once you see there's an individual capacity action, the rest of it falls into line, because the whole point of individual capacity is to have damages. Damages are presumptively available against a non-sovereign, and without damages, officials can literally treat the law like garbage. On constitutionality, it is undisputed. Respondents admit they must comply with RLUIPA within the scope of their work as officers in a federally funded state prison. And this court has already held in Salinas that officers in a federally funded state prison can be held individually liable for misconduct that threatens the integrity or proper operation of the program, and that describes this case to a T. So RLUIPA is clear, it's constitutional, and we're asking the court to reverse. I welcome the court's questions.
Do you have examples of causes of action for damages that are viable as a result of the exercise of the spending power?
I mean, I think there's many statutes that have causes of action under the spending clause. I mean, under Talevsky, this court held that it was enforceable under Section 1983. We also give a long list in our brief of spending clause actions that include civil liability running all the way back to the founding. I mean, we give an example of a 1789 law, the false claims.
How would you get to the authority under the spending clause to create these damages actions that you suggest?
So I think there's sort of two paths.
Or in this case?
In this case, I think there's two paths to do it. One is to follow the path that this court has set forth in Salinas, in particular, Salinas, Dixon, Laudani, and Hess, and to just hold that.
What was Salinas about?
Salinas was about an officer in a federally funded state prison who accepted a bribe to provide preferential treatment.
Isn't there a difference between a bribe and a lawsuit for individual damages?
Well, he was being held individually liable for criminal penalties, which I think is something that clearly requires the necessary and proper clause in addition to just ordinary civil.
The argument there was that if you provide the funds, you have a right to protect it.
I mean, I think that protection of funds, well, maybe sort of two things. First, in Salinas, when the court was describing the thing that was interfering with the proper operation of the program, it wasn't the acceptance of the bribe. It was the preferential conjugal visits. It was the misconduct itself. And so just applying the test that Salinas set forth, and I think actually my friends don't.
Make that clear, there were no federal funds at issue. The bribe was going into a correction officer's pocket, correct?
That's right. There was no diversion of federal funds.
So no risk to the government's money.
Pardon?
No risk to the government's money.
That's at least certainly not direct. If anything, it was prophylactic. And here, I think it's really much more direct.
Slow down, counsel.
Sorry.
The question there then was the risk to the government program, correct?
Correct.
And here the risk is to what?
To the government program to accommodate religious liberty. I mean, that's the heart of this program under RLUIPA is if you want federal funds for state prisons, you need to accommodate religious liberty.
Now, going back to Justice
question is, were his
Thomas's
religious
question about other statutes that are at risk,
liberties,
if we were to hold that you can't
whatever,
bind
stopped
third
by,
parties,
they held him down and shaved his
dozens
dreadlocks
of
off
them cited by you and the government, where we've permitted
in violation of his religious
causes of action,
beliefs.
damages, Title IX, Title VI, the Federal Nursing Home Reform Act, the Emergency Medical Treatment Act, the anti-fraud statutes. There's a long list of statutes where we said
the question is, can they be held liable?
Bind third parties, correct?
Correct.
All right, thank you.
Counsel, the basis for state liability here is, of course, an agreement with the federal government, right? In other words, they've cut a deal, get the money, and they're going to be have to comply with these conditions. But there was no such arrangement with the defendant in this case, right? They didn't have a direct relationship with the federal government. They didn't get directly any federal financial assistance. So you don't have the same basis for liability as we do in the other typical spending clause case, right?
Right, it's indirect, right? Because the officer, and what this court said in Rust is that if a person goes to work for a federally funded program, then they take the job subject to the conditions that Congress has attached to the funds. And of course, I think they're already admitting, again, that they're bound by the substantive condition, really by virtue of their choice to voluntarily work as officers in a federally funded program. And so I think it's that sort of the chain of privity is the thing that makes this case sort of considerably easier, I think, than a case like Sabri or some others where you're trying to reach somebody who's a member of the general public. Because these are not members of the general public. They're state officers. They voluntarily accepted this job. They each have all of their own employment contracts, and they take it subject to that condition. I think one thing that's also sort of relevant is that as state officers in a prison, individual capacity damages are the norm for them. We have an amicus brief from former corrections officials who talk about how, of course, this is something that they're all trained on. Everybody understands this because under Section 1983, individual capacity damages are just the paradigmatic remedy.
But the hard part, as I see it for your case, for me, is that you need a clear statement, and appropriate relief, is not as clear as it could be in encompassing damages. So how do you deal with that? I don't want to water down our precedent on that, but at the same time, I want to hear your response to how you get there.
Yeah, I think it's sort of the first thing, and I'd love for you to look at it, is just to lay eyes on the individual capacity action. It's in the PEDAP at 41A. It's got a cause of action. It's titled Judicial Relief is the name of the statute, and then subsection A, cause of action. A person may assert a violation of this chapter as a claim or defense in judicial proceeding to obtain appropriate relief against the government. Who is the government? You go in a few pages, and it says an official or any other person acting under color of state law. And that's just obviously individual capacity. Tanzan already says that. It says that it provides a clear answer, and the text is identical. And then I think once you see there's...
On Tanzan, I'm not sure it quite says clear answer. I think it says it's the best answer. It's a traditional answer. I'm not sure it quite says...
Sorry, one step. On individual capacity, it says...
Oh, yes. I'm talking about damages.
Yes, and then once you see there's individual capacity, because I think it's expressed on the face of the statute...
I'm asking about damages.
Right. Then at that point, the Franklin presumption kicks in, because you have a cause of action against a non-sovereign. And the ordinary rule at that point is where there's a right, there's a remedy, right? There's a right, Congress has created expressly the cause of action, and damages are presumptively available unless Congress says otherwise. It then taps into the very deep tradition that Tanzan sets out of individual capacity liability that goes all the way back to the early republic. That's what these have always been for, is to obtain damages. And if you can't obtain damages, the individual capacity actions is totally meaningless. You can already enjoin them in their official capacity. So the only thing you get is damages. And then I think also, when you look at just the operation of this statute, the statute just doesn't actually provide its promised protection in a large set of cases if damages are not available. And it's not just this case. I mean, I think if you go through the amicus briefs, there are many situations,
working for you guys, right?
some very ugly
Acting
ones
a little funky
where
on my end, so I wanted to make
effectively
sure.
the statute is ineffective. And I think one of the things that's particularly troubling about the way respondents' rule would work is that the very officers who are like violating the law can also basically unilaterally decide to turn it off by transferring the prisoner to a different facility. And so even if...
Sorry, go ahead. Please finish.
So even in a case where injunctive relief might be helpful, they can moot it out by transferring the person. And I think, yeah.
All right, on that point, and then I want to get back to the Chief Justice's question. As I understand it, the circuits are unanimously against you and have been for many, many, many years. So saying that something awful is going to happen, it's all right, whatever's happened has happened, right?
That's correct. It's happening. Yeah.
Yeah, and it's been this way for a very long time in every circuit in the country.
That's correct.
Yeah. On the Chief Justice's question, I'm struggling. Where I'm struggling is, where did the defendant, the individual defendants, agree with the federal government to be bound? And what notice did they have? And I understand your point earlier to the chief that they're subject to state regulations and with their contract with the state. And of course, an agent can be liable to his principal for violating what the principal dictates. But the agent isn't normally liable to a third party for a breach of the principal's duties with respect to a third party. So even when the agent causes the breach, even when the agent negotiates the contract, he's not liable to the third party. He's only liable to the principal. So if we're looking to background contract principles, to the extent they're relevant, and maybe you're going to tell me they're not, that's fine. But to the extent we would, it wouldn't seem to encompass these defendants. And every circuit court in the country would appear to be correct.
So
help me with that.
Yeah, I think what that's missing, we trace this out in our opening brief, is that contracts are extraordinarily flexible, and you can, and people do.
Yes, okay. Your brief does go into that, that Congress could have easily written a statute that does this and says that those individual officers have to agree with the federal government to be bound under federal law. I agree, it could have done that. And you say it could have done this in 15 different ways in your brief. I agree with you. My concern is it didn't do that. It could do that, but it didn't do that. It left it to the states.
I think that's really where I fundamentally disagree.
Okay.
I think Congress did do it. What it said in this statute is that, first of all, obviously the states need to accommodate religious liberty, and then it is clear as day that if you agree to be an officer or other person acting under color of state law in this statute, and you deprive a person of their religious liberties in violation of this statute, then you are subject to suit where you will be the defendant in a cause of action for appropriate relief. That is on the face of the statute. And the individual officers, they can agree to take the job or not. They can demand higher wages. They can demand indemnity like Louisiana gives it. And I think one of the things that really breaks down in their argument is they admit that it applies to them. They admit that they need to comply within the scope of their work. And it comes not just with the substantive condition, but also with a remedial one. And then I also do want to just come back to, in this court's precedents, it's made clear that that Congress can combine the spending power with the necessary and proper clause to impose liability. I mean, criminal liability in Salinas and Sabri.
I don't doubt it could, and I don't doubt that when it's protecting its money, as in some of those cases, Salinas, that interest is clear. What I'm struggling with is, did it? Not could it, did it? Did these individual defendants have notice? Did they agree? Would you agree that the individual defendants have to have notice?
I think as the way this court's precedents work, the notice runs to the state, and then as defendants...
So the defendants don't have to have notice?
Why don't they have notice if they have
if I might just finish, I'm sorry. So, do the defendants have to have notice?
If I could
yes
be clear,
or no?
If I could be clear, it depends on which way you think about it. There's one way to think about it, it runs all the way through consent, and then, of course, they need notice because they took the job. They have to take it subject to the conditions.
Counsel, it's just really simple. Do the individual defendants have to have notice?
They have to have notice of the condition when they sign up to it.
And do they have to consent to the conditions?
I mean, they consent by virtue of taking the job. Yes.
Do they have to consent?
By taking the job, yes.
Is that a yes, they have to consent, or is that no, they don't?
I mean, under this court's, sorry, I just want to be clear about this.
I just want to know what your answer is.
My answer is that they did consent here, that if you're going to think about this purely as a matter of consent, which we traced through in our opening brief, then of course they need to consent. Okay. I think this court's cases go farther. Mr. Sabri did not consent.
I understand.
Right?
I understand the fraud cases, but I'm asking, do they need to consent? And I'm hearing maybe not.
Not under this court's cases.
Thank you.
This court's cases go farther.
Can I follow up with that just on the facts of this case? Because as I understand your argument, we do have both notice and consent under these circumstances, given that these individuals as third parties are not just people in the world, they are employees of the recipient of federal funds. And so to the extent that the recipient of federal funds has made clear with the federal government that it's going to require its employees to comply with RLUIPA and not violate people's rights, then when those employees choose, consent to accept a job with that employer, they are thereby consenting to follow those agreements. Is that right?
That is exactly right. And I think that's why when this court has had these cases, Salinas, Dixon, Hess, Laudani, it's a whole line of cases involving officers, agents, employees, subcontractors, where there's this chain of privity.
Yes.
Every time the court has I think, actually seen that in Salinas said there was no serious doubt. This is not a hard case.
Because chain of privity is a classic contracts concept, so that even if you thought that contracts was governing this, we have individuals who, for example, I suppose, let me just give you a hypothetical. What if the prison in this situation actually appends to its employment contract all of the conditions that it has agreed to with the federal government? And of course, the prison can only operate under its employees' not direction, but because there are employees. In other words, the prison doesn't have its own activity. So to the extent that it agrees with the federal government that it's going to comply with RLUIPA, it's saying, I and my employees, the agents that I employ, are going to do this. And so let's say the prison actually appends to its employment contract all of the conditions that the federal government requires for the receipt of federal funds, so the person who is choosing to be an employee is totally apprised of what it is that is required as a condition of employment. I understand your argument to be that that would be sufficient, even if we assume that there has to be notice and consent to satisfy any such agreement.
Of course, and I think what this court has said, if I could, in Russ versus Sullivan and then in Alden versus Maine as to state officers specifically, is when you go into this job, when you go into this line of work and you voluntarily agree to be an officer in a federally funded state program, then yes, you implicitly, you necessarily take it subject to the conditions that Congress has attached to the funds.
Thank you, counsel. Your answer that you've just given to my colleague is based on a legal fiction, right? If you're hired as a prison guard in Louisiana, you don't sit down, and I don't even know if Louisiana does, saying, oh, here's our agreement with the federal government.
I had a thing set up for today that would have told you who was talking.
And you should look at it carefully because you're bound by it. That's not what happens as a matter of practice. And I don't think when the prison guard is hired, he says, well, I want to see the federal conditions that you agreed to under the contract.
I mean, I certainly doubt that anything like that happens, but we do have the amicus brief of the former corrections officials that talks about how there is training on compliance with federal law, that individual capacity damages are the norm. And again, they're not disputing that they need to comply with RLUIPA's substantive condition in the scope of their work. And I think what they haven't come up with is any kind of reasoned explanation why Congress can impose the condition on them, but then can't enforce it, especially through civil liability, when this court in Salinas, Dixon, Hess, and Laudani has already done that and actually gone farther, and I think Sabry goes considerably farther.
Thank you, counsel. Justice Thomas?
A lot of what we're talking about today is
analyze this any differently under spending clause
detention
than we
facilities
would
and
under
liability.
one of the enumerated powers.
I think that the spending clause, of course, impacts the analysis. I think it impacts the textual.
How does it impact?
Well, I think from this court's cases and like Dole, among other things, that there needs to be clear notice, which is why I started there, and I think it's been fully provided.
Do we throw out in that analysis the contract analogy or framework?
I think the contract analogy is a helpful framework, I think, for understanding the scope of the spending clause alone, but this court has made clear, and respondents are not asking you to overrule any of your precedents. This court has made clear repeatedly that Congress can also combine spending with necessary and proper. And I think one of the things that's unusual about this case is that this is within Congress's power either way you look at it, because of the chain of privity gets you there on consent, and then Salinas gets you with necessary and proper. I mean, Salinas is criminal liability, which is never available by a contract, whereas this is just civil. This is an ordinary remedy available as a matter of contract. I think this is really much more in the heartland of Congress's power.
Justice Alito?
Just out of, just out of curiosity, did this prison shave the heads of all of the prisoners?
As I understand it, yes, that was the rule.
They shaved the heads. They didn't allow any type of, even a short haircut?
I guess I can't speak to the length, but as I understand it, the rule across the board was everybody who comes in gets their hair cut. And I think it's really the paradigmatic example of the kind of inflexible and unyielding rule that Congress, in enacting this statute, was trying to get states to stop if they wanted to accept federal funds, that they needed to accommodate religious liberty.
If the language of RLUIPA was not clear enough to abrogate sovereign immunity in Sosamon, why is it clear enough to satisfy the spending clause?
I think it's really two answers. The first is, as Tanzan explained, and this court has said many times, you always understand text in context. And the context of what's appropriate in a suit against a sovereign is very different than the context of what's available against an individual. This court said this in Sosamon. It also said it in Tanzan. The tradition as to a sovereign, of course, is you don't get damages, but as to an individual, this is a tradition that runs all the way back to the founding. I mean, damages have always been available in that context. And so I think the context is probably the clearest answer. I think there's also some suggestion, if you compare Franklin and Sosamon, that the clear notice standard on the spending side is not as demanding as the sovereign immunity, but I think you don't need to get into that because the contextual difference is so clear.
Well, why should it be less demanding under the spending clause? When the question is whether Congress has abrogated sovereign immunity, the question is whether Congress has done something to itself. When the question is whether Congress has imposed a condition on the state, the question is whether Congress has done something to another sovereign. Why shouldn't the standard be at least as strong when it is doing something to another sovereign, to the employees of another sovereign?
So on that, first of all, Sosamon was as to another sovereign, right? It was as to the state. And I'm not fighting.
I understand that, yes.
I think I'm comfortable with it being the same standard. I mean, but I think we have the clarity. It's drawn from context. And I think one of the things that's very different about this case than this court's other recent cases in this area is this is not an implied right of action. There's nothing implied here. This is not implied enforcement through Section 1983. This is an express right, an express remedy. It expressly runs against an individual. And as Tanzan said, the distinction from the sovereign context is obvious.
To the extent that prison officials have been doing things that violate RLUIPA but wouldn't violate the free exercise clause, who is to blame for that?
The conduct on the ground?
Well, who is to blame for the situation that allows that to happen?
I mean, I think under this court's decision in Employment Division against Smith, there is some daylight. And the crux of this law, I think, is that Congress wanted to ensure that any state prison that accepted federal funds, this is the heartland of the law, provided greater accommodations, provided pre-Smith protections, and damages were vital to the pre-Smith scheme, as Tanzan made clear.
Justice Sotomayor?
I see the issues here on two levels. The first is it clear that an individual is bound by the statute? Is there an express cause of action? And that's clear. It says anyone can bring a suit against a government official or someone acting under a color of state law, correct?
Correct.
So the second step is it clear that the cause of action includes money damages? That's the next step of the analysis,
correct,
right? And your argument, I believe, is that Tanzan says that appropriate relief against individuals always includes damages. So does Franklin in a long list of our jurisprudence, correct?
That's correct. That's the traditional rule, is that damages are available unless Congress says otherwise.
So those two things are clear. So in terms of contract principles or causes of action, this is clear. Now, what my colleagues, and I think that was Justice Gorsuch's question, slightly different, which is, do we need to create special rules under the spending clause? Because generally speaking, if you're a prison official, you know you're working in a prison and you're bound by law to pay damages if you violate the law. Do you get an out because what? I think the consent question means what? Or notice and consent means what? And I don't know, meaning we're all presumed to know the law. When we take our jobs, the correction officers know he can't accept money. Citizens know they can't pay the money. We don't expect them to consent to that spending clause condition, do we?
I think one of the things that makes this case so much easier is that you have the consent of the person to become an officer in a federally funded program.
I agree, but I don't know why you need that. I think that's what you were saying, which is we never think of needing some express consent to say I'm bound by the law.
I think really the hard question in most of the court's spending clause cases is, can Congress impose the condition on that person? That's really the question in like Sabry. Can Congress actually impose the condition on that person? That can be a hard question, but it's not here. They admit at page 46 of their brief that they are bound by the substantive condition.
Your point is if they're bound to the injunctive and declaratory judgment relief, then they're bound to the money debt.
It's an exceedingly small step, and this court has gone—
It's not even a step.
This court has gone well beyond it, and I think you can easily get there as a matter of even just as contract principles.
Thank you.
Justice Kagan?
Mr. Tripp, the questions you've been getting, is there enough consent? Is there enough notice? I presume, tell me if I'm wrong, would those questions apply just as well to any 1983 suit against a state employee?
I mean, I think a lot of the notice questions are going to the sort of spending clause layer, which—
Yeah, but of course 1983, we've said, applies when a statute is based on the spending clause power. We said that most recently in Tlefsky, and there are other cases. So if we take ourselves out of the RLUIPA context for a second, we just put ourselves into the context of some other spending clause statute which doesn't have its own cause of action, but where the cause of action is 1983, presumably you would have the exact same questions about, I don't know, does the state employee know about this? Has the state employee consented to it? And yet we've never thought about those questions in that context, have we?
That's right. I think you don't ask that follow-on question. And there was no additional question about notice in Salinas. There was no additional question about notice in Sabry. I don't think there was either in
John,
Dixon.
it's just kind of when this one ends.
You run down the line.
Yeah, I'm just sort of saying that out of the RLUIPA context, just 1983 statute.
Theory, it's an hour for each, but
the 1983 statute used to enforce spending clause statutes. I mean, we just take for granted that, of course, you can bring a suit against a state employee.
That's correct.
And then it's like, why would the rule be any different?
Oh, is it only a half hour?
I don't think it should be.
Justice Gorsuch?
In fact, in Medina, we said the spending clause adds a layer to the 1983.
Oh, it was only a half hour. They really didn't expect for there to be much question
in
here.
terms of notice and consent, suppose a federal statute said something like this. If
Oh,
a
this is
coach
the,
at a
I see what you're
federal
saying, yeah.
funds receiving university allows biological men on a women's sports team, a female trying to make the team could sue for $1 million. Or an employee of a federal funding recipient in a state agency dealing with family affairs gets an abortion, the father can sue the employee for $1 million. I think on your theory, those are perfectly fine without any particular notice to the individual employee or any particular consent by the employee.
Maybe I can come back to one of the answers I gave before. The rule we're articulating has 4 ingredients. You need to have a valid condition that applies to the person. They need to be an officer within the scope, and then it needs to threaten the integrity of the program. I think under your hypotheticals, the real question is the first one. Can you actually attach the condition
Let's assume
to
you
that?
can. Let's assume you can. Let's assume they're germane.
Thank you, Dominic.
And they might be germane, in terms of, for example, the student athlete might well be germane to a concern about discrimination against women that a federal funding program might well take into account under Title VI, for example, or the employee for the Health and Human Services that might, a pro-life Congress might well think that germane, and we might well find it so. So take as given that they're germane. I can come up with other examples if you want me to.
No, I just want to be clear that this court's Dole test is already sort of addressing these concerns, right? So there's obviously the relatedness requirement, but then it also can't be coercive, and then you can't have an independent constitutional bar.
Suppose there's no constitutional problem with these?
And then if these people qualify as officers, which is not clear to me that they will.
Let's say they do.
Then it would, then yes.
And it follows.
Because the answer would be.
So the
well,
spending
sorry,
clause-
hold on. Sorry, I think I missed one step. And then within the scope, which I think you have, and then it would need to threaten the integrity and proper operation of the program.
Yeah.
And I think it is telling you that if, and this is the big
I
if.
think, Mr. Tripp, where you're winding up is the spending clause is no different than the commerce clause.
I really don't think that's correct, Your Honor, because the crux, the most important condition on the Dole side is you can't have coercion, right? The state needs to go into it eyes wide open, and I believe in your hypotheticals, the person needs to take the job eyes wide open. And so those are very significant checks that mean this is never going to get to the same.
Both of those checks exist in my hypotheticals, and Congress could pass such laws. And that's quite a stretch of the spending clause. We've never before said anything like that.
I mean, if this court wants to cut back on some of the sort of frontline sort of scope, maybe you could do that in some future case, like in the hypotheticals.
I'm not talking about cutting back anything. I'm talking about what 9 circuits have uniformly done since RLUIPA's passage about 30 years ago.
Yeah, and I want to be clear that once Congress, and I'm not going to back down on this at all. Once Congress can impose the condition on the person.
I wouldn't expect you to, Mr.
Once they can impose the condition within the scope of their work, and that can be that's a hard question, but here it's not. Okay. And once they can impose the condition, they can enforce it. I think that's the only step that we're asking about here. We're not asking you to change any law on the front end about what Congress can and cannot do in the first instance.
Justice Kavanaugh?
Back to the question on
will somebody send me
damages
puppy kisses? I want to test something.
You rely heavily on Tanzen for that, but even after Tanzen, to pick up on Justice Gorsuch's point about the courts of appeals, the courts of appeals have continued to reject the position you're articulating here, even in the wake of Tanzen. Chief Judge Sutton's opinion in Ali is probably emblematic of that. It says even after Tanzen, you still don't have the clear, express, unequivocal, unambiguous authorization for damages. And so my question really is just why are judges, to Justice Gorsuch's question, misreading
Thank you very much.
precedents that are out
Almost
there
worked.
in your view?
Yeah, I'm glad you asked that. Maybe 2 points where I think Judge Oldham has the better of this, with all due respect to Judge Sutton. And honestly, is the first thing that I said. Judge Sutton, if you look at his opinion in Ali and also his prior opinion in Haight versus Thompson, he does not ask the question of whether there's an individual capacity action. He goes right into the sort of appropriate relief analysis. And I think that is just a critical step, because once you see that there's an individual capacity action, then you have an express right, an express cause of action, expressly against a private party. And then whether damages are appropriate relief, I mean, that's the norm. That's what individual capacity actions are for. If you don't have it, the individual capacity adds nothing. It's totally meaningless. And I think it's because Judge Sutton sort of overlooked that first step in the analysis that I think Judge Oldham has the better of it. I also think that when you're asking, once you're actually turning to the question of, okay, we have the individual capacity action, we're trying to figure out what is appropriate relief, another thing that Judge Oldham hit really hard, which is very powerful, is the whole point of this law, which everybody knows, is to go back to the pre-Smith scheme and provide the same rights and remedies that were available, including in the original RFRA, which this court said, made clear, must include damages against state officials. And so I think that the parallel, I mean, these are hardly even separate statutes, right? Like RFRA and RLUIPA, they work together as an integrated whole. And so to understand them, I think that really the only way to understand their operation together is as providing the same rights and remedies within their scope. I mean, RLUIPA, Congress was crystal clear in RLUIPA about the places where it needed to trim its sails because this was spending legislation. It's on the face of the statute. It's not RFRA 2. It's the Religious Land Use and Institutionalized Persons Act. It only applies to institutions that accept federal funds. That's on the face of the statute. It's clear as day. But if you look in at the substantive provisions and the remedies, and you look, well, how have those changed because this is spending legislation? The answer is not at all. The rights and the remedies are the same. The whole point of this statute is to get back to the pre-Smith scheme.
The whole point of the spending clause jurisprudence is you need more of a clear statement to get all the way there for damages. I mean, at least.
And I think really what I'm saying is that, and this court has said this many times, is the question is it unambiguous? And to answer that, there's no magic words requirement. You read text in light of context like you always do. And if you do that, and you start by asking, is there an individual capacity action? It's clearly yes.
And just to summarize your position, individual capacity action with appropriate relief equals clear authorization for damages, correct?
What I'm saying is the first step is individual capacity action, you have it, and then the question becomes, well, what's appropriate relief in an individual capacity action? I think the answer to that is clear. That's actually, Tanzan says, I know it's not applying a clear statement rule, but its language bespeaks clarity each step of the way. Said that Congress made clear that RFRA must provide damages, that there was no doubt damages were available before Section 1983, that it was going back, and then again, the distinction to the sovereign context, where damages are not available really because of a special rule in the context of suits against sovereigns, right? The crux of Sassamon was that it could distinguish Franklin. It distinguished the Franklin presumption because it doesn't apply to sovereigns.
Thank you.
Justice Barrett?
Mr. Tripp, how could it have been clear to states when every circuit, as Justice Gorsuch pointed out, every circuit had said that there were not damages actions available against non-recipients under RLUIPA? That's also true under the Title IX context. So it's hard to see how it could be clear to the states that were accepting the money or the prisons accepting the money that it was a clear condition when all of the law went the other way. What would your response to that be?
I think a couple of responses. The first, what this court has demanded every time, and I've said this before, is unambiguous text in light of the context. And this court has never applied any kind of like canon of adverse possession, where if the courts of appeals are saying something.
You were a lawyer to the states, and that was the state of the law.
B-Rad,
and the state
look right
asked you
here.
about that. What would you have said?
Can you see that?
I think the key here is to look at the time when the statute was enacted, right? And which is the key question, right, is what did it mean when it was enacted?
Are you able to read that right
and
there?
if you look at it when it was enacted and you pick it up and you read it, I think as just a state officer working in a federal...
And it's so obvious that
I'm not being
every single
sarcastic. I wanna
circuit to look at
see
the
if it's,
question went the other way.
Move it over a little
so
bit.
It's hard to see how it's clear if every circuit is coming out differently.
And I think this is actually an important point because the prevailing rule in the circuits, including the Fifth Circuit below, where this case is coming from, they didn't deny that there was clear notice. They said it would be unconstitutional because they thought that the officers were like, they treated them as non-recipients, even though they're basically indirect recipients, and it didn't sort of see
I was trying not
that
to
they
block.
fit within
Well, not every
You're
circuit
talking, you're
brought up
chatting.
the constitutionality question, but putting that aside, can you identify, putting aside the bribery cases, can you identify any cases in which a non-recipient of funds was held individually liable under a federal statute?
I mean, that's better. I wanted to make sure you could also see what you were saying.
In Grove City College
What was
versus
in the
Bell,
text?
you're reading
Chat.
an indirect recipient. In Salinas, Dixon, Hess, and Laudani, those are all situations where you're reaching.
You can just say that, yes, it would be a different factual scenario.
I don't have a case that's on this exact factual scenario, I admit that, but I think actually this is like a lesser included of Salinas, and it's way inside Sabry. I mean, it's nowhere close to that.
But I said put aside the bribery cases. So,
if I could push back on that a little bit, I think
Put it
that's
over the
important.
bookshelf, then you wouldn't be able to see it.
The
I have
crux
to
of
move
this
the blue
program
box.
is to
It's a-
provide federal
it's a whole
funds to
thing.
prisons that accommodate religious liberty.
well, no, I asked you to put them aside because I wanted you to put them aside and look at the civil liability context for a minute. I
Okay,
think
yeah.
that Sabry and Salinas are the best cases for you, particularly Sabry. I take that. But if those are distinguishable, I wanted to ask you the other question, and I think the answer is no. And I think, and I just kind of want to clarify your answer to Justice Gorsuch, look, the facts of this case are egregious. So if on the facts we were looking for a case in which there should be money damages, this is it.
This is it. The facts
Justice
here are
Gorsuch asked you a
insane,
series of
guys.
harder factual scenarios in which we might think, I'm not sure if money damages, as a policy matter, make as much sense in that context. You never really gave him an answer, yes or no, and so I just want to say, I want you to give me an answer, yes or no, on Justice Gorsuch's hypotheticals, and don't fight the hypothetical about the conditions and all that. Your theory means that, yes, the coach, the doctor, could be held liable.
let me be clear about that.
Yes
If,
or
but
no,
only
yes or
if
no.
the
Take his
condition.
no,
if, but only-
Mr. Tripp, he asked you to assume that the conditions, that it was perfectly consistent with the spending clause. So yes or no, would your theory say that, let's talk about the coach under Title IX. On Justice Gorsuch's hypothetical.
If the condition is valid.
Yes, yes, he
then I'll
said
say
all that,
Yes,
yes.
if the condition attaches, Congress can enforce it. And I think the crux of the question is.
Okay, but
can
just say yes or no, yes or no. You don't want to say yes or no. Just take the consequences. It's totally fine if those are the consequences. But I think you have to follow the logic where it leads. And the logic where it leads is that, yes, under Title IX, say, Congress could pass a statute, or Congress could say that it's going to rely on its spending power to hold the coach liable under the hypothetical Justice Gorsuch gave you, right? Yes. Yes.
Yes. But I think this is.
I just don't see how you could say no, given the assumptions he asked you to make about the spending clause.
But I want to be clear. One of the reasons I've been articulating this rule under Salinas, right, which is these 4 ingredients: valid condition, officer within the scope, and threatening the program.
Because
is
once
it
they
doesn't
admit
require
it,
you to
they've
address,
locked
I think,
in
some
an
of these. There
answer.
are hard hypotheticals
Well,
about.
but Mr. Tripp, every time we decide a case, we have to think about what it's, in Salinas and Sabri, if they had looked ahead to this case,
This
might have
is
said, yeah, this
Landor.
might be where the logic leads, or you take a few steps from here and this is where it goes. But we can't decide a case just based on these facts. So you just
Where
need to own
Louisiana
it.
prison
No,
guards
And it's fine if
and
you
I own that.
it. just
Handcuff
I want to be clear about
a
that.
man, a
But
Rastafarian
what
man
I'm
to a
saying, and
chair
the reason
and
why,
shaved his
especially in our reply
dreadlocks
brief,
off.
we're relying heavily on Salinas, is you've already said all of this. And so we're not asking the court to break new ground.
But you're not making, well, okay.
And-
Let's
and-
just, but logically speaking, why does it have to be individuals or officers? Why couldn't you, for example, say that a school district, schools that take federal money, if they do, and we want to, why couldn't liability extend, say, to parents who choose to send their kids to those schools? Let's think about, like, if a child is transitioning, say, and the parent says, no, I'm not going to facilitate that, I'm not going to call the child a different name or call the child by different pronouns, could there be some sort of cause of action that would allow, say, the child to sue the parent for civil liability? Why does it have to be an officer or an employee under your theory?
But because of the consensual contractual nature of
Remarkably
agreeing to
respectful
work
for-
as an
So
officer of a
contract works
federally
for
funded program.
That point.
Right, and so I think when you're reaching a member of the general public, which is what your hypothetical is talking about, it is a totally different set of questions that we're not remotely touching. I think that's what Sabri gets at, is how far can Congress go into reaching members of the general public? Those are hard questions, and we're not asking you to go anywhere near them.
And why doesn't your logic require it? Because you want to rely on the contract analogy for that point. Like you're just sticking on the contract road.
Because of the contract road, and they admit the condition applies to them. And it's because of the contract, because they've agreed to take the job subject to this condition. And we know that that's voluntary all the way down, right? The state is voluntarily accepting the funds. They're voluntarily taking this job. A person who takes this job might want to demand higher wages or indemnity or things like that, but that's already the norm for them, and they already provide the, indemnity is the norm in Louisiana law in most states.
What about other contracts, though? I mean, what if you, contract for services with the hospital because you're a patient? What if you contract, I guess I don't understand why it has to be an employee.
I think the piece about being an employee, and this is what's picked up in Russ versus Sullivan, and Alden versus Maine as to state officers in particular who also take an oath to comply with the federal constitution and laws, is that you are sort of taking the job sort of subject to the conditions, the sort of terms that attach to the work. It's different than being just like a stranger to the counterparty in a contract.
Yeah, you're stuck with that
I
answer.
know that in Hess, United States Marcus X. Hess, that's a situation where you're reaching somebody who's a subcontractor through the sort of a chain of privity. And so the court has addressed that in some other cases. But again, I think this one's easier because of just the nature of the work.
Okay, speaking of the layers of consent, this is just a technical question. The Fifth Circuit talked about the warden and the Secretary of State. Were the guards actually defendants? Because here, are the guards before us?
We don't have their names. They're John
The
Does.
John Does, but the Fifth Circuit didn't talk about them. The Fifth Circuit talked about the warden and the Secretary of State saying they couldn't be sued in their individual capacities.
The warden is the
I don't think
factual
it's about-
allegations in the complaint involve the
Rarely
warden
behaved woman, it's not
specifically.
about whether or not the
Okay, and the
issue
word-
is
so the
black and white,
warden
but whether or
knew
not the
you're-
argument
okay,
is black
so
and
the-
white.
The Does are not before us. It's just
I mean,
the
no,
warden.
the Joes are before you. We don't.
Before you-
It was dismissed.
Right.
We don't know who they are. Yeah.
Okay.
We don't
They're
have their
trying to
And in terms of layers
block
of the
off
contract, is
chunks
the contract
to
with the
make
state of
the
Louisiana
end
or
answer
with
smaller and
LADOC
smaller.
or with the prisons?
So the way RLUIPA works is the Department of Corrections
Okay,
is
so
the
it's LDOC. That's
LDOC.
just, yeah, I just wanted to understand how that worked. Thanks.
Justice Jackson?
So can I invite you to reflect back to Justice Thomas's question?
This is the whole
and
universe.
you said that there were two
They want to
paths
keep cutting
to
out
getting
areas,
to your
so when they make their
results. And you
final
mentioned
ruling,
Salinas is
it
one,
won't
and I
apply
think
to the
I'd
whole
like it
world,
for
it'll
the
only
other,
apply to
but let me
this,
just
and then it'll only
give you the
apply to this,
opportunity
and then
to
it'll only,
explain what those
yes
two
or no?
paths are.
Yes is
Yeah,
up
and
here,
so
no is
in
down here, so we can
Salinas,
cut this
I think
part
because
off,
it's
and we can
criminal
cut this part
liability,
off,
the
and we can
court
cut
is
this
very
part off,
clearly
and
relying
finally,
on
the
a
final rule
combination
will
of the
only
spending
apply
clause
here.
to attach the condition,
want
and then
smaller.
the necessary and proper clause to enforce it, because you can't do criminal under contract. But I think in this case, because we have civil liability and it's this chain that runs down to the officers, you don't even need the
Still
necessary
waiting
and
on
proper
Kim
clause.
Davis, I
I think
think.
this is an unusually easy case because of the way that
So
just sort of
the chain of privity is the second.
because the chain of privity is the second. So I think you could come at it either way. And, you know, I represent a private litigant. I don't really care which one you do, so long as you reverse, of course.
So do you view Louisiana's constitutional argument as turning on the contract analogy? I mean, do we have to sort of accept that the spending clause and spending clause legislation is subject to characterization as a contract in order to buy their argument?
I'm not sure. Maybe they can speak for themselves on that. I think the spending clause is properly understood as being the spending clause alone. I think it is consensual in nature. I think this court has been clear about that. But then the question of
But we've also been, I just want to be clear about this. I mean, we've also expressed pretty significant, in many cases, doubts about whether the contract analogy
I'm
totally
going to mute
governs.
myself for a second so you
yeah,
don't
and
hear the
that's what I
printer.
was about to say, because
Yeah.
it doesn't get, this court has also been clear, and they're not asking to overrule any of your precedents, that Congress can invoke the necessary and proper clause to protect its spending prerogatives. I mean, look in our reply brief, we have the example of the statute that makes it a crime to arson a federally funded institution, right? That's the use of the necessary and proper clause in conjunction with the spending clause, and which, as I understand their brief, they're saying that that's off the table. Whereas I think what we're saying is because this is officers, you know, within the scope, it's a valid condition, and it's conduct that threatens the sort of core operation of the program, then it's just controlled by Salinas, and you don't need to break any new ground.
So how much precedent would we undo if we held that RLUIPA's individual capacity cause of action for money damages is unconstitutional? I mean, is this a big deal case or not so much?
I mean, I certainly think it's a big deal case, and we've included, I mean, I think there are these like 5 or 6 precedents from this court that I just don't see how they can square their position with. Salinas, Hess, Laudani, Dixon, Grove City College versus Bell, and Sabry. And then just above and beyond the court's cases, I mean, we traced through a history of statutes that are similar to this, running all the way back to 1789. The first Congress imposed that had a scheme for imposing individual liability on officers in working in a federally funded state prison. False Claims Act of 1863, anti-kickback provisions that started in the 1930s. Title IX, Title VI, that's Grove City College versus Bell. Title X of the Public Health Acts, EMTALA, there's whistleblower provisions, Prison Rape Elimination Act, the arson statute that we were talking about. There's another one about blocking interference to federally funded programs. So it's a long list of statutes.
That could be imperiled
Yeah,
by...
where Congress has traditionally protected federal programs, and I think in particular imposed conditions and enforced them as to people who are in this position of being in the chain of privity. They're officers, agents, employees, or subcontractors of the grantee.
Thank you.
Thank you, counsel.
Okay, so guys, the Kim Davis case, I don't see an answer. What I see is that they have denied a request for an amicus brief from someone, which I don't know if that means.
Thank you.
Oh,
Mr. Chief Justice,
the petition
and
for
may it
writ of
please the
cert is
court.
denied.
RLUIPA clearly authorizes
they've denied the writ of
individual
cert
capacity damages
for
suits
Kim
against
Davis.
state officials. Tanzan held that RFRA authorizes individual capacity
That is
damages
huge.
suits against federal officials, and RLUIPA is RFRA's sister statute and should be read the same way. Congress used materially
I'll be back in
identical
1 second,
text
guys.
in RLUIPA to provide the same remedies as RFRA against state officials. Respondents resist that simple conclusion because RLUIPA was enacted under Congress's spending power. But RLUIPA's language puts states on clear notice that state officials can be sued for damages in their individual capacity. And under the spending and necessary and proper clauses, Congress can create personal liability for state officials acting as agents of the state when they violate conditions on federal funding. Indeed, Salinas and Sabri upheld more expansive uses of Congress's power to impose criminal liability. I welcome the court's questions.
Well,
I'm actually,
let's say
I'm
that
actually
the
live right
state
now,
is
so
under clear
with the
notice. Is the guard
Supreme
also
Court, but I wanted to read this.
privy to that clear
Because
notice?
this was just
So,
released.
Justice
The
Thomas, we
motion,
don't think clear
so
notice
Kim
is
Davis
required
case,
under
the petition for
purpose of
writ
the
of
spending
certiorari
clause
is
because
denied.
we care about
So
the notice of the
Supreme Court will
recipient, but
not
I
be
think the
hearing the
officers
Kim
here
Davis case
clearly had
about
notice, and I do
the
think that
future
qualified
of
immunity.
Kim
So how did they get
FYI,
that
thought
notice?
you guys should
And
know
what
as
was
quickly as
the
possible.
notice?
Well, I think the statute clearly applies to them. If you look at, Petitioner's Counsel emphasized the text of the cause of action, it applies to a government defined as an
So
official.
do you think they were aware of the state's commitment to the statutory requirements?
I think that we're all sort of held liable for what's in the United States Code, and I think that this isn't surprising to
So
state
you think
officials.
you have clear notice of everything that's in the United States Code?
Well, Your Honor, I think that the officers here clearly had notice. Officers are used to facing 1983 liability and are liable for violation of all constitutional provisions. They know that certain requirements apply to them when they accept employment in a federally funded prison. And I do think that qualified immunity is an important backstop because they can only actually be held liable if their conduct violated clearly established law.
And they concede liability, right? I mean, in other words, they concede that these substantive provisions apply to them. So they must then know, or, their response was not, we didn't have notice that we had to behave this way. Their response is, you can't sue me individually for damages as a result of that.
Exactly, Justice Jackson. At page 46 of their brief, respondents admit that they are bound by the substantive condition. I think that makes this a very easy case for purposes of the spending clause issue because they admit they can be sued in their official capacity for an injunction. I think that means, as Petitioner argued in his brief, and I don't take respondents to have disputed, that respondents could be held for contempt, and that can have personal consequences.
I'm sorry, finish your question.
They could be held for contempt, and that could have personal consequences. So I think that the necessary and proper clause, if it means anything, it can mean that Congress can go one half step further and say that we can reach these people in their individual capacities as a necessary and proper means to enforce the substantive condition of RLUIPA.
Well, I think the necessary and proper clause may mean other things, even if you're right. But so in light of what you've said, your answer to Justice Barrett's questions is yes, right? They can be held liable whether they know, whether they don't know, quite across the board.
I didn't think they
For
would
government
either.
officials, yes.
I
As to
thought
the
Gorsuch
hypos, I think
told
that
us they
one of
wouldn't,
Justice
but
Gorsuch's
they did.
hypos, which Justice Barrett followed, might have included private parties. The government doesn't take a position as to how this would cash out in terms of private parties. I think, as Petitioner's Counsel noted, I think there's obviously different issues of consent, especially when we're talking about reaching a member of the general public. But in terms of reaching government employees and agents, we think that they can clearly be reached. I do agree with him that
So even though we require pretty express consent by the state before they're bound under the spending clause, we don't require that with respect to the individuals.
Your Honor, no, I think what matters for purposes of the spending clause is clear notice to the states who accepted funds. And again, this isn't surprising to individual officers.
So you're saying, does the same standard apply to the individual employees?
No, I do not think under the spending clause that they need to have clear notice.
That's got to be the implication of your position, is that both clear notice and consent, this court has said time and time again, are required for states to be bound. and you're saying neither of those apply when it comes to state employees.
So I guess I should clarify my answer that I do think it depends on what power the court relies. I think if the court
Spending clause.
if the court were to say only the spending clause, then I do think that you would have to have consent of the state official, and I do think we have that here.
Whoa. Let's back up. We're talking about a spending power statute, okay? And everybody has to agree, I think, that consent and notice are required for a state to be bound, right?
Yes.
And are you saying those are or are not required for the state employee to be bound?
So under the spending clause, I think that the sort of privity argument that we've been talking about today.
So no is the answer, because it works for the state, and because the state employs these individuals, they're necessarily bound.
I do think that's right, and I think that's.
So no consent and no notice is required for the employees. That has to be the logic of your view.
I think not as a formal matter in terms of under the spending clause, but I think the reason that this is such an easy case under either the spending
what do we
clause.
do if that's true? And I think it has to be. You're right, and I appreciate the candor. With the fact this court has always said that contract is the analogy, and it's certainly true that an agent is liable to his principal for violating the principal's rules. Here, the employee to the state. But it has never been the case, well, never may be strong, but certainly if I look at the restatement, an agent isn't responsible to a third party with whom the principal has a contract. Privity doesn't run like that. It runs between the principal and the agent, not a third party. What do you do about that?
Yes, Justice Gorsuch. Well, I would strongly resist that the contract analogy applies to answer every question that arises in spending clause
That's an
legislation.
answer. It's just ignore this contract analogy.
Well,
Fair enough.
well, I think that I think what the court's cases say is that the contract analogy is important for purposes of determining notice. It's did
notice
the recipient
and consent, yeah.
Did the recipient have notice? I think here it makes it an easier case under the spending clause, unlike all of the cases where the court has considered, like in Medina.
But you're asking us to ignore contract principles when it comes to the employees, right? I mean, that has to be right.
No, we just don't think that the contract analogy answers the question. We think the court needs to sort of tick through the constitutional analysis and ask, is this a necessary and proper means of enforcing the substantive RLUIPA condition? And we think it is.
We have to look outside the contract analogy because it wouldn't get to the employee here. It wouldn't. I mean, there's no privity between the employee and the federal government.
There is not, but again, the necessary and proper clause gives Congress the power to enforce a condition that's validly imposed. So once we have a valid condition that has been imposed and to which the state consented, surely Congress can take the half step further to enforce that condition against the people who are most likely to violate it.
No, Ms. Baird, so it sounds to me like you want to use the contract analogy to limit the scope of this argument, because you keep saying, well, no, this is privity, and that's why we don't need to take a position on whether it would reach a member of the general public, right? But then you're moving away from the contract analogy when Justice Gorsuch is asking you about, well, do these principles of contract law apply? I don't understand. It seems like we're slipping in and out of the contract analogy.
Yeah, so let me try to be clear, Justice Barrett. I think that the contract analogy applies to determine whether there's notice. I think this court's cases are clear that the notice that matters is the state's notice. I do think that the officers can be fairly held to account for notice here. I think under the spending clause alone, this is an easy case because officers consent to work at a federally funded state prison. I think when we add in the necessary and proper clause, the farthest this court has ever gone is Sabry, which reached a member of the general public. There was no consent there. I think that the necessary and proper clause allows Congress to enforce valid conditions. There may be hard questions about can Congress impose the condition in the first place? But I think once Congress has imposed the condition, and again, respondents don't dispute that they're bound by the substantive RLUIPA condition, and courts of appeals have upheld the substantive condition under the spending clause, Congress can go one half step further and enforce it against individuals.
That half step has to include members of the general public, because you're relying not just on the contract, because the answers about the contract are that it does not need to give clear notice to the employee. So they're getting their notice from the statute, right?
Yes, I think they have notice from the statute. And again, I think qualified immunity is an important backstop for officers. I guess with what I would say about members of the general public is I think conceivably, and the reason we're not taking a position on sort of how this non-party liability issue cashes out there, because I think there conceivably could be different analysis under the necessary and proper clause. I think here, it's necessary.
What would that analysis look like?
Well, so let me just walk through what the analysis is like for individual officers, and then as I'm doing that, we can sort of see how it'd be different. But here, it's necessary to enforce it against individual officers because otherwise the condition would go unenforced in a significant category of cases. And the facts, as alleged here, are a good example of that. Facts of one-time abuses.
You can finish your answer.
Thank you, Mr. Chief Justice. That Congress clearly had on its mind in RFRA and RLUIPA, you know, the destruction of a Bible, et cetera.
Louisiana
It's
government
also
side
proper
arguing, I
because this
believe.
is a long-standing traditional remedy, and it's against state officials who are most likely to violate the condition. These are the people through whom the state acts. The state otherwise doesn't act but through its officials. And so I think that necessary and proper analysis could look a lot different when we're reaching a member of the general public, and I think there could be other safeguards. I mean, there are other limits on spending clause power too, and I think those would equally apply.
Thank you, counsel. Justice Thomas? Justice Alito?
In determining whether there
I
was
also want to
clear
say,
notice,
sometimes
what is the relevant
you
point in
notice
time?
after a while when
So
you're
I
saying
think it
things
would
like,
be,
I
what is
think,
the
a
notice
lot. You
as
have to
provided
listen
by
for
the
it. It's
statute?
hard
In
to
Medina,
notice
I think it
when
was
it's yourself.
footnote 8. The court said we care about notice as provided by Congress.
No,
So
what
it-
date? What is the
You have to be
date?
very careful
So
about
when
that.
RLUIPA was enacted in 2000.
I see it a lot now when I'm
we
watching
care
my
about
videos.
It's not the
Like,
con- it's
oh, I
not
said
the
that
point
word
at which the
twice
state
in 2
accepts the
sentences, and
money.
it's really
yes,
noticeable.
but I think so yes, we care
Thank
about
you,
the
guys.
state's notice at the time they accepted the funds,
And
but
what
I
was
think
what is the relevant date there
so.
in
I,
this case?
RLUIPA is tied to all sorts of federal funding, and so I don't have a specific date on which they accepted funds, but I imagine they're continually accepting federal funds. You can go to usaspending.gov to see the different funds that they receive from the government.
Was it clear before Tanzen?
Yes, I absolutely do think it was clear because Tanzen is illustrative. I think Tanzen is helpful for us because it shows why the textual analysis comes out the way it does. I don't think it was necessary.
Even though all the courts of appeals had gone the other way, and even without Tanzen, you think it was clear?
I would say so, Justice Alito, and here's what I would say. I mean, in talking about the Courts of Appeals decisions, yes, they've all gone the other way. I agree with Petitioner. Not all of them said that the statute wasn't clear. I think that really there's no sort of how lopsided is the circuit split rule. It's odd to think that at time zero, a statute could not provide clear notice or could provide clear notice, but then at time one, when all of the circuits have gone the other way, it doesn't provide clear notice. There's just no administrable way to administer that
Your
rule.
screen,
And
guys.
so
Tanzen was decided, I think, 18 days before the event in question here, and maybe General Aguinaga.
No, I think
answered
oregano,
the
I think you
question, but,
nailed the point.
if funds were not received after that date, doesn't that make it more difficult?
I don't think so, Your Honor. I think that timing is right from what I understand the allegations to be in the complaint. But I don't think the argument depends on Tanzen.
But I
the
do
notice
try
that
to,
we care about is the notice as
alternate,
provided by
so I'm not
Congress,
using the same
and text
phrase
is the
over
only
and over again,
reliable
which can
indicator of
also be a
meaning.
problem.
The other thing I'll say is sort of just as a basic principle, when Tanzen interpreted RFRA to make clear that individual capacity damages are available under
Likely.
RLUIPA 2, that's not just what RLUIPA meant post-Tanzen, that's what RLUIPA has always meant. That's Rivers
Okay,
versus Roadway Express.
I understand the point. Could you address?
Yes, they are not going to hear the Kim
Justice
Davis
Gorsuch's
case.
hypothetical about
Just
the coach?
released
Let's
that.
just take
Just
that as
released
an
a new list of
example.
cases they will
What is
not
the
be
position
hearing.
of the United States regarding that
Writ
situation?
of cert is
So
denied.
assuming the coach, this is a public entity and the coach is a government employee, yes, there could be a cause of action there. But again, I think the difficult part, and I'm not going to fight the hypothetical, I think yes, but
Reno,
the
it was
difficult
just
part is
their
can
policy.
Congress impose the
Everybody in
condition
there
in the
was,
first place? And there are serious limits on what Congress can do
What's the
under the
word?
spending clause. There's not just dole, but there's other principles that the court has laid out.
Yeah,
that
and
are
what
within-
would be,
sanitary
that's what I'm
issue.
asking. What would be the
There's
limitations?
just their policy
Sure,
across
so
the
there's
board.
several. I mean, the dole factors, obviously, there's
Well,
the
would the dole
unconstitutional-
factors be met in that situation?
Well, I don't want to take a position on sort of
Sorry,
the outer
Megan
reaches
Freeze.
of the spending clause because this case is really about enforcement, and so I don't want to get ahead of the United States on very difficult questions about how far does the spending clause go. I think the important thing is that there are limits. The dole factors, there's the unconstitutional conditions doctrine. Congress can't condition funds on someone giving up their constitutional rights. There's coercion. And then I think the remedy itself has to be constitutional. It has to comply with due process. And then as I was talking with Justice Barrett
Maybe
about
trying
it,
my
also
best
has to be
because there's an
necessary and
opinion here,
proper. So there may
apparently,
be
as
some
well.
instances in which a remedy is not necessary to enforce a condition or a proper means of enforcing the condition, and those requirements can have teeth.
Well, you're asking us to take an important step. It would be helpful
It's not Davis, though. I was
we
wondering.
had an idea
Not
about
Davis.
where this
I
road
was
is
like,
leading,
but
but
it's
you don't
not.
want to provide an answer to that.
Well, Justice Alito, I think because it's not presented in this case. I think that when the court
Veneno
has a spending
Jr.
clause case about how far Congress can go in imposing the condition, then I'm sure we'll be up here as a party talking about that with you. I think that the United States hasn't sort of taken a position
Gorsuch
on
and
that
Thomas
question because
How often has this court held that Congress has imposed an impermissible condition under the spending clause?
I mean, NFIB is an example.
Yeah. What else?
Alliance for Open Society, there's a First Amendment violation there. There are real limits. I think in Prince said that there was a necessary and proper case,
Native
said that it
American
wasn't
tribe,
a
and Gorsuch is
proper means
really
of
big on Native
enforcement. So I
American
think that the court can, if it wants, address that in a separate case. I think really the question here, and I'm not trying to frustrate the court,
you're
but
correct,
the question
Sonia,
is
sorry.
really just, can Congress enforce a condition that is validly imposed? The hard question in Your Honor's hypothetical is whether Congress can impose the condition, and at page 46, they admit that they are bound by the condition. The only question is one of enforcement, and Congress can certainly, again, if these officers can be held for contempt and subject to personal consequences, Congress can surely hold them accountable in their individual capacity for damages, which everyone knows that is what RLUIPA was trying to do.
Thank you. Thank you.
Thank you.
Justice Sotomayor?
A new road by us would be to rule for respondent, correct?
I would say so, Justice Sotomayor, yes.
It would put at risk dozens of federal statutes, correct?
I think so. If the court says that neither through the spending clause or the combination of the spending and necessary and proper clause, Congress can't do this, then I think that would be groundbreaking, yes.
Similarly groundbreaking is the requirement that somehow when individual damages are at risk, that Congress has to be more specific than using appropriate relief, because we've approved damages under appropriate relief in other statutes, haven't we? Spending clause.
Well, yeah, and Franklin's a good example of this, because in Franklin
exactly.
there was not even an express cause of action. So if we're concerned about clear notice and what clear notice is, here we have an express cause of action that expressly applies to these officials and expressly provides for appropriate relief.
Thank you, Counsel.
Justice Kagan?
When you just said, Ms. Baird, groundbreaking, could you hum a few more bars on that? I mean, groundbreaking how? Groundbreaking what would happen, what would follow?
Sure. Well, I mean, I think petitioner's brief laid this out nicely, but there's sort of a long history of Congress being able to reach outside of the strict privity between the federal government and an entity that receives funds. I think all of that could be called into question. I think we've cited some sort of on-point statutes in our brief where employees or agents can be held liable. That's the Federal Nursing Home Reform Act, EMTALA, Title X. And then I think if the court accepts respondents' arguments on the constitutional issues, I think that could call into question Section 666, the bribery statutes, and Sabri. I think that this case is such an easy case because this case does not even approach the outer limit that this court has recognized in Sabri as permissible. And I think all the court has to do, the court does not need to extend Salinas and Sabri. I think all it has to do is cite those cases, say that no one has asked us to overrule them. Case
On
closed.
Salinas and Sabri, I mean, one of respondents' arguments is that those cases are different because the federal government's interest in funding was more directly involved, that what they really were all about was ensuring that the federal government could
word for word on it is very upsetting,
sure that the
frankly.
recipient didn't fritter away the federal government's own funds. So why is that true or not true?
Yeah, so we would strongly resist that RLUIPA isn't about protecting federal funds. It absolutely is. The federal government gives money to prisons, to state prisons, on the condition that they won't violate religious free exercise. When they do that anyway, the government is not getting what it pays for, which is institutions that respect religious exercise. So I do think that this is about protecting the funds. I'll also say that in Salinas and Sabri, the court was concerned about more than just protection of the actual funds at issue, and I think you can see this because neither case required any nexus with the federal funds. It's most obvious in Salinas, where the court there described the threat to the federal program was the deputy sheriff who was giving preferential treatment to the inmate. It was clear as day that that was the threat that the court was talking about. And I think here the federal program is similarly threatened when officers can violate conditions on federal funds with impunity.
So in those cases, what the court was really saying is that the federal government has every right to deal only with institutions that are not generally corrupt. And here, it's the same, except the end of the sentence would be not generally rights violating.
I think that's right, Justice Kagan. The federal government does not want to be a party to egregious violations of religious liberty like the facts alleged in this case. I mean, the federal government has the power when it says it's giving federal funds on a condition to enforce that condition, and the state can always say no.
Thank you.
Justice Gorsuch?
I take your point that a holding that said that Congress could never pass a statute conditioning employees, making them follow RLUIPA, because that would exceed necessary and proper bounds, would be quite a holding. But the same would go for the coach, too. On the Title IX recipient, there'd be quite a holding for us to say Congress couldn't do that. I take that point, but I think it would apply to the coach as well. And I also think it's very different to say whether Congress could or couldn't do it. It didn't provide the clear statement that's required. And there's nothing novel about that. We just did that last year in Medina, for crying out loud, right?
Well, Your Honor.
At the government's urging.
Well,
right?
Your Honor, yes, I think that was right.
All right, and then,
but,
and then we'll go. If you want to finish, you want to add, feel free.
Oh, I was just going to say there's a really important difference between this case and Medina, which I've sort of mentioned a couple times, which is this case involves an express cause of action. So I think in Medina,
I understand that. The question is to whom, and whether there's clear notice. And simply saying it's not clear notice and there isn't consent, there's nothing novel about that. We did that in Dole, we've done that in Medina, we've done it, not in Dole, but in a lot on other cases, we've done that, right?
I think that's right, but I do think there's clear notice here, Justice Gorsuch.
I understand you think that. No, on the clear notice point, you say, well, it was obvious even before Tanzen, right?
Yes, Your Honor.
What do we do about the federal government's representation in Tanzen itself that RLUIPA does not clearly authorize these suits against individual employees?
Yes, Your Honor, that's a fair question. So we were a party in Tanzen. We took a shot at the text, what we thought was a good interpretation of the text, and admittedly, we had an interest there in defending federal officers against damages suits. But hey, we lost, and we lost very badly. It was 8-0.
Well, that was RFRA, and absolutely you lost badly. But you said, with respect to state officials and RLUIPA, that it doesn't authorize. And now you're asking us to believe that it was clear, even though you got it wrong. So,
Justice Gorsuch, we've taken to heart this court's decision in Tanzen, and I think that Tanzen's analysis really does help the court decide the question. It doesn't govern squarely, but I think it does illustrate why the text means what it does here.
Justice Kavanaugh?
You agree that a spending clause statute must unambiguously authorize damages in order for damages to be available, correct?
Yes, I think that's the clear notice requirement.
Okay, and do you have any differences with petitioner on why you think this statute, RLUIPA, clearly authorizes damages?
I mean, I think petitioner put it about as good as I could. I think that it's really important to start with the individual capacity action. I think if you look at this text, it is clear as day that it applies to officials in their individual capacity. It applies to an official or any other person acting under color of state law. I grant you that if we were looking at appropriate relief in isolation, I think it'd be a much harder question, but we're not. The question that Tanzen started with, and I think the court should start with here, is who is the defendant? And that makes all the difference between Sosaman and this case, because in Sosaman, the context of a sovereign defendant, there's absolutely no history of that. Damages are extremely inappropriate against the sovereign.
A whole other case to go
whereas, and Tanzen lays out this history in a really helpful way, in the context of individual officers, damages are the norm.
It's the attorney for the Louisiana government.
I agree with this or not, but just to get the order of potential operations on the table, if we were to conclude that this statute does not clearly unambiguously
open this back up again for a minute.
That avoids all the groundbreaking issues that you've been discussing, correct?
Well, I think you would also want to consider sort of downstream consequences with respect to RLUIPA if the court says that the text
I understand that.
Clear.
My specific question was the groundbreaking consequences you were discussing. That would be put off for another day, correct?
That might
Even
be.
though you think, and I take your point, and that's why I said I'm not saying whether I agree with this or not, there would be RLUIPA consequences.
Yes, I think there'd be RLUIPA consequences because I think there would be a question about the alternative jurisdictional hooks of the Commerce Clause. I think you'd also call into question the alternative jurisdictional hooks in the land use context because there'd
doing
be
a great
question
job,
of
yeah,
whether that
considering-
interpretation governs those separate
holding her own.
powers. And I think the court should just sort of follow the text where it leads. This is a legal question like any other legal question. We think the notice is clear. I do think that that would probably be less disruptive than sort of all of the other consequences I was talking about with Justice Sotomayor.
Thank you.
Justice Barrett?
So I just wanted to clarify one point. You said that if there were not individual, if there was not individual liability for damages available here, it would make it hard for the federal government to protect its money, because this was in response to Justice Kagan, because the federal government doesn't want to give money to prisons that are rights violators, essentially.
Marcellus, read under my.
But the federal government,
read right
we
here.
usually say in the spending clause context that the remedy is for the federal government to pull the funds, right? So it could do that.
That is an option, Justice Barrett, I will say. So, and I'd have to go back to check every single case, but I believe that the cases in which the court has said that, there's no express cause of action. And so, yes, I think the court has said in a case like Medina, for example, when you're analyzing this hard question about can this right be enforced via 1983, I think there's a default presumption that Congress wants to enforce it by pulling the funds. But here, Congress made a policy choice to enforce it through creating a cause of action. And this isn't unusual. We all know what Congress was trying to do. It was trying to restore pre-Smith rights and remedies, and that had long been available under the First Amendment through 1983. So I think Medina makes clear that it's a policy choice whether to create a cause of action. Congress has done that here, and we think that should be respected.
So you think Congress couldn't pull the funds here?
Oh, no, I think that might be an option available to the federal government. We also have a cause of action for the federal government to enforce RLUIPA through injunctive and declaratory relief. But I guess what I'm saying is that the fact that that's a usual remedy, the court has said that in cases without an express cause of action. And I think, so is that the usual remedy? Maybe in those cases. I don't think that's the usual remedy here because Congress told you how it wants to enforce.
I see. Is there any daylight between you? The question the government always gets,
Yes.
do you stand with petitioner all the way, or is there any difference in your position?
No, I don't think there's any daylight. There might be, like, if you drill down, like, there might be some small differences at the margins, but I don't think there's anything that would matter to the court's resolution of the case.
And one other question. So there's been a lot of talk about whether there has to be clear notice in the contract to the employees or whether the statute is enough, and the government and the petitioner say the statute is enough. But the statute could have, or Congress could, in giving the funds, right, in the spending clause context, it could say to LADOC or whatever state prison system it's contracting with that it has to be a condition of the contracts that the guards would be liable or that individuals be liable for damages, right?
Sure. I mean, yeah, petitioner has laid that out and says this can all be done through contract. We agree with that, but I don't think that that means that what Congress did here is impermissible. I think that there's clear notice on the text of the statute. I think how a state responds, how a Department of Corrections responds, I think they should inform their officers. There are briefs saying that officers are informed of the requirements that govern
Individuals not
prisons.
still
I do
incarcerated.
think that officers expect this. This isn't surprising. They're not some disinterested third party. These are people who work in prisons and know the conditions that apply to them.
This was a relatively
Jackson?
short
So I
incarceration.
guess I'm trying to understand how Congress could have said it any clearer. I mean, to the extent that we're puzzling
Yes.
over whether or not there's a clear
Prisoner
statement
walked
in
in
the
with a
statute,
copy of
it
the
says,
ruling from the
"A
Fifth
person
Circuit
may
saying
assert a violation
another
of
rough
this
fine,
chapter as a
handed
claim
it
or
to them, and they
defense
threw it in the garbage.
in a judicial proceeding and obtain appropriate relief against a government." If that doesn't refer to money damages being brought by an individual for a violation of RLUIPA, what could Congress have meant by appropriate relief here?
I mean, we agree with you. We think it's clear, especially once you look at the definition of a
Oh, do you
government,
agree?
appropriate relief against a government becomes, the word appropriate relief becomes clear in the context of who we're talking about here, which is individual officers. So we would agree.
it
And
was
even
5 months, and
broadening
this
out
was
the
only the
lens
last 3
more,
weeks.
I mean, RLUIPA is applying
Because
to
he was
prisons
transferred
in a
for the last 3
circumstance in
weeks.
which
This was done
the
right at the end.
PLRA and other statutes make it very difficult for prisoners to get any other kind of relief, right? I mean, they can't
And
get
they handcuffed
injunctive
him to a
relief
chair.
in any sort of meaningful way.
I think they could. I think prisoners could get injunctive relief under RLUIPA, and we would say that's another form of appropriate relief. But I do think that damages are necessary to complement, especially for instances like the one alleged here, where there's a one-time abuse. I think it also comes up in cases of when claims for injunctive relief are mooted by release or transfer.
Or transfer, which can happen all the time.
Yes,
so
and it's very, very common.
And, okay. You've said many times that this is an easy case, and I think it's because of the privity argument. I'm trying to kind of puzzle through it. The state can say no to the condition in this situation. It has notice. It's a part of the agreement that the state makes to accept the funds, so it can say no to the condition that it must follow RLUIPA. But then we have this other layer, which is the employees, I suppose, can say no to a state that has agreed to the condition, right?
I think that's right. They have a choice whether to voluntarily accept employment in a federally funded program.
Against the backdrop of a clear cause of action against people in their position for violations of the law.
Yes, I think the statute is clear as day that it applies to individual officers, and in that context, appropriate relief clearly provides
And
damages.
don't we ordinarily hold people responsible, especially officials, for knowing what the law requires and following it?
I think that's generally a presumption that this court has endorsed, yes.
Thank you.
Thank you, counsel. Mr. Aguinaldo.
Thank you, Mr. Chief Justice, and may it please the court. The court should resolve this case on either of two grounds. First, you should say, as Chief Judge Sutton has said both before and after Tanzan, that RLUIPA does not clearly and unambiguously create an individual capacity cause of action for damages. Or, second, you should say, as Judge Sullivan has said after Tanzan, that even if Congress spoke with unmistakable clarity and created such a cause of action, Congress exceeded its constitutional authority. But however you affirm the judgment below, it is extraordinarily important that the court reject petitioner's attempt to radically expand congressional power. His view of the spending clause would mean that foundational cases like Pennhurst and Cummings were confused, Mr. Chief Justice, because Congress can actually impose spending conditions on non-recipients too. And his view of the necessary and proper clause would make Sabri look modest, Justice Thomas, because, on his view, Congress doesn't even have to pretend to be protecting federal dollars and cents from corruption before regulating members of the general public. Now, to be sure, I have a lot of friends on the other side of this case who have valid concerns about Congress's silence over the past 25 years when 10 federal courts of appeals have said that there's no individual capacity claim for damages under RLUIPA. But the solution is not to distort this court's existing precedents to try to change that status quo. It is instead to tell Congress to act exactly like it did in 1993 after Smith and in 2000 after City of Bernie, which is to pass new legislation, supersede SOSAMON, and amend RLUIPA to allow for damages against the states. And then the states can decide, each state for itself, whether it accepts that express condition. The answer is across the street, not here. I welcome the court's questions.
Congress is across the street.
There's been quite a bit of reliance on Sabri and Salinas. Could you spend just a few moments giving us your argument as to why these cases aren't dispositive?
Absolutely, Justice Thomas. So if I could give you the one sentence that I think might be the most important in this court's precedents for this case. That's the very last sentence of Section 2 in Sabri at page 608. This is the paragraph where this court in Sabri rejected Mr. Sabri's spending clause challenge. He said that this legislation is coercive.
And the question is whether or not they were allowed to.
No, it's not spending clause legislation at all. This is not Congress's attempt, 666 is not Congress's attempt to impose its will on states' choices about public policy. It's instead Congress's necessary and proper clause authority to basically target those who convert public spending into unearned private gain. That's the line that the Sabri court drew. And Justice Thomas, I think that is exactly the line, the framework that you should keep in mind when asking, what is RLUIPA? Is it more like 666 where you're targeting actual federal dollars and cents? Or is it like true spending clause legislation where what Congress is doing is imposing its own policy choices on the state recipients of federal funding?
But the actual dollars and cents weren't at issue in that case. What what the court was upholding was the federal government's right to say we shouldn't, we need some strings in place to ensure that the money we pay to a federal institution is going to an honest federal institution, an institution that won't be profligate with our money generally, even though there's no nexus with the money here. And so too, the government can say, the integrity of the institution has something to do with not taking bribes, and the integrity of the institution has something to do with not violating rights. And both of those things fall within the federal government's interests.
And respectfully, Justice Kagan, that's not consistent with Sabri. Look at page 606. This is the money is fungible paragraph that spans 605 to 606.
Money is fungible,
the
indeed.
theory that the court was articulating there to sustain statutes like 666 is to say, what is the articulated federal interest in the statute? And the very last sentence of that paragraph says the federal interest here are federal dollar thresholds that Congress embedded in the statute as its putative protection. Now, I'll grant you, Justice Kagan, that Sabri, I think, has to be the outer limit of the Congress's necessary and proper clause authority, because what it was doing there really had no direct tie to the funds at all. But the theory that this court cited in justifying reaching the result it did was to say, we're going to look at the federal dollar thresholds in 666. We're going to say, well, Congress is at least pretending to protect those federal dollars.
I'm sorry, but it's the same thing here, meaning they're trying to protect their federal dollars from not supporting a program that violates religious liberty. So I'm not sure that that distinction makes any sense to me.
Your Honor, that's not correct, because there's a very important difference between Congress protecting its constitutional authority to spend and its constitutional...
And it has constitutional authority to spend and give money to state prisons as well.
But
it wasn't in those programs. It could spend on programs, but it didn't have to.
But what Congress does not have inherent sovereign authority to do under the spending clause is regulate. The only way it can regulate is if the recipient of the federal funds agrees in return.
But a criminal statute is regulation.
It absolutely is regulation, Your Honor, but what I'm saying, what this court said in Sabri is that a statute like 666 is not spending, that's not a spending condition at all. And that's why I think the most important starting point in this court's analysis is to ask, is this a spending condition? The federal government agrees at page 23
If we disagree with that.
And I'm happy to take the disagreement, Justice Sotomayor, but I do think that that line that this court drew at the end of Section 2 in Sabri is the right way to think about this. And I think...
Do you agree, General Aguinaldo,
Sometimes I can't tell whether they're being
as a spending condition,
jerks
the federal
or they're
government
nervous,
could
and this is
have
how it comes
told
across.
Louisiana Department of Corrections that it had to include a clause in the contract telling individuals that they would be liable for damages?
Absolutely, Your Honor.
Why is this so different then?
It's different because, the word privity has been thrown around a lot on the other side of the case, and with all due respect, I don't understand that. When we're talking about consent in the spending context, you're asking whether the ultimate regulated entity has in fact consented to whatever the conditions are. And in your hypothetical, Justice Barrett, I think you can conceive of Congress saying, we're going to require you to basically require a contract of assumption by your employees, where anytime an employee comes into the state and says, I want to work for the state says in response, if you're going to do that, you have to agree to these specific conditions that the federal government has imposed on us. There is nothing like that contract in this case, and that's why I think all of those hypotheticals at the end of the blue brief about how Congress could have created direct contractual privity between a state employee in his individual capacity and the federal government doesn't hold up, because at the end of the day, what they're telling you is what Congress could have done. You don't see that line here.
But aren't they saying that if you have the contract and then you have LUPA on the books, that the combination of those things essentially is the condition that the employees were aware of?
Your Honor,
when they signed up for the job?
Your Honor, that is not how this court's spending clause cases conceive of consent. And I think every employee in the country would be shocked to learn that just by accepting employment with their employer, they have thereby personally bound themselves to contracts.
What state, damn it,
Go ahead.
what state remedies did these guards have? This was egregious. Is there a state RLUIPA?
There is, Justice Barrett, as we said.
And would that have provided relief to them if they had chosen to sue under it? As far as I can tell, they did not.
They did not sue. Arguably, the answer would be yes, Justice Barrett. At pages 13 and 14 of our bio, we describe our law, which basically mirrors RLUIPA, expressly provides for damages, and that was available. That's available to all prisoners in Louisiana, and it's available even to non-prisoners in Louisiana.
And it would permit money damages?
It has money damages expressly articulated in the statute, Justice Barrett.
Go ahead.
Well, I was just going to say that was certainly one remedy that was
think
immediately
that was the
available.
ballgame.
I will say in terms of the broad scope
everybody
of remedies
agrees
available
this was
either to
egregious.
Congress, if it's unhappy with a state like Louisiana, or otherwise, the remedy. Sorry.
Yeah, no. I mean, I understand that. I mean, I just really did want to know as a matter of state law. And then just out of curiosity, obviously this is beyond the record. I mean, was there disciplinary action here? Do you know?
So it is outside the record, Justice Barrett. I can say the warden himself is no longer associated with the Department of Corrections.
Good. They took this case, they accepted this case because the facts were so extreme.
Employees would have. Are they surprised to learn that they find themselves subjected to 1983 suits all the time?
Well, Justice Kagan, Section 1983 is a remedy, right? It's a cause of action that gives a remedy. And your earlier question about can't you just do this all under 1983?
I didn't say can't you do. What I'm saying is that your arguments that they're not getting notice, that there's not enough knowledge. I mean, that would just make 1983 suits. The same objections could be held with respect to that, and yet 1983 exists. People bring 1983 suits against state officers all the time, including to enforce statutes that have been enacted pursuant to the spending clause.
That's right, Justice Kagan, and remember that when we're talking about 1983, the antecedent question, at least in the spending clause context, is whether the asserted right under the spending clause legislation is one that can be enforced in 1983. And I think the important point there in that antecedent question is the question we're dealing with in our red brief is, can Congress use the spending clause to create a substantive right that runs against a state official in his personal capacity? And if the answer to that is no, then you never get to Section 1983.
Didn't we answer that question in Tlefsky? I thought we said in the 1983 context that it didn't matter that it was spending clause legislation. We said a law is a law.
We said secured by the laws of the United States include secured by laws enacted pursuant to the spending clause.
That's right, and the question in this case is, does Congress have constitutional authority under its spending clause power to do what petitioners say it did?
No, but I'm saying, why are you not undoing that Tlefsky holding with the argument that you're making today?
Your Honor, because cases like Tlefsky are dealing with suits that are actually against recipients, funding recipients, right? I mean, that's nobody disputes that in the—
That's just a distinction you're bringing in. What I think Justice Kagan was getting at is there's something about your argument that turns on this being spending clause legislation, and that has something to do with the extent to which it can be enforced in this way.
Can you hold
we
the
said in the context of
individual
1983 that
prison
it didn't
guards
matter
liable
that it was spending clause legislation.
financially
And what she, I think,
for
is
that?
trying to say is, why should it matter here? And if it does matter here, doesn't that imperil the determination that we made in Tlefsky that spending clause legislation should be treated just like any other law for this purpose?
Your Honor, it matters here because of cases like Cummings that trace all the way back to Pennhurst that say the very legitimacy of Congress's exercise of spending clause authority depends on that bilateral agreement. Is it sending money out and taking a reciprocal promise to comply with conditions in? If you're missing that reciprocal consent from a recipient or putative non-recipient—
So what's your answer to the other part of this, which is the
JR, I think there's a
states—
specific law in place here that deals with the liability, and that's
I know
the
they're
question.
not the ones that are being bound, but the first step is, did they consent to follow RLUIPA?
I have to be very precise about this, Your Honor.
The
Yes, the
RLUIPA,
state
whatever,
consented
however
to
it's—
RLUIPA's plain
When it
terms.
accepted the money, it did.
That's exactly right. And my friends love page 46 of our red brief. What we're saying there is that when a state official in his official capacity is working on the job, he is the state under this court's common division between official capacities and individual capacities. And of course, state officials in their official capacities as the state are bound by RLUIPA.
I'm sorry, are you saying that this individual who represents the state, on page 46 of your brief, you said he's bound by this statute, correct? Substantively as an official of the state.
In his official capacity, of
As a
course.
state.
He is the state.
So he is the state.
He is the state.
So you say it's enough knowledge for him to know what the law says and that he's working for the state and he represents the state, that he can't violate the law, correct?
I don't think these were contractors,
and if
but
an
I could be
injunction
wrong. I
issues,
don't
he
think
could
they
be
were.
held liable for violating
The other case we're going to look
that
at
law,
is
correct?
Because it's an injunction against the
contract.
state,
All right,
Justice
but you're
Sotomayor.
saying at the same time, that
the case
person
that
who, the
should have started
warden,
40 minutes ago.
who is cutting the individual's hair should know that that's a violation of the state for which an injunction should be liable, but he shouldn't know that he's liable for personal damages too. That's what you're saying.
Your Honor, that's what 10 federal
this is
courts
an
of
emotional
appeals have
case.
said.
Well, that's
And
what they
that-
said, but as the other side pointed out, they didn't start with the first question, which is it this
No,
statute
this was a
clear
5 months.
that there's an
This was
individual,
not a major
a
charge.
cause of action? Yes, it does make that clear. And is it clear by using appropriate damages clear that it includes appropriate relief that includes contract damages? In Tanzan, we said yes. So whether they're right or wrong, it's irrelevant. If we assume that the law says what it says, how do we say that official acting as a person knows one thing is wrong for the state, but it's not wrong for him to do, or her?
So Justice Sotomayor, I think that goes back to an earlier question Justice Alito asked of the federal government, which is, what perspective are we looking at? I was surprised to hear the federal government say, you look at the time of enactment when Arlington Central, Justice Alito's opinion for the court, and then Cummings, the Chief Justice's opinion for the court, said, you look at when the official is deciding whether to receive federal funds, what
So
would that...
frankly, that would mean that, do you know when they took, I thought federal funds came every year.
And that's my point, Justice Sotomayor.
So every
is that
year, they know that they're bound. So does it make a difference if we say, it's clear enough, but it wasn't clear to them at the time they took this action because 10 circuits
They didn't really give an
were
excuse.
wrong.
It was just the
But
policy
moving
at the jail.
forward, it's
They
clear
shaved
enough
they
to
cut
anybody
everybody's hair when
else
they came in.
that they shouldn't do it.
That's the very last argument we put in the red brief, Your Honor, which is if you disagree with everything else I say about the constitutional questions, then that, I think, has to be the answer. And I will say it's not just what has
It's a
happened
form
between...
of qualified immunity you're arguing.
What I'm saying, Your Honor, is that between the year 2000 and Tanzan, I think certainly we have this huge body of RLUIPA precedent that would have put no state prison on notice about prison officials being liable in their individual capacities. But even
How many of those cases were post-Tanzan?
we have four...
Tanzan was 2020. We have this case, but how many of those were post-Tanzan?
I believe we have about 4 circuits post-Tanzan, Your Honor, and that includes Chief Judge Sutton in Ali versus Adamson. That includes Judge Sullivan in the Tripathy case out of New York. And the other thing I was going to add to that answer, Justice Sotomayor, is that I'm happy to rely on the body of RLUIPA precedent, but in the spirit of footnote 6 in Sosamon, which looked at a pre-RLUIPA precedent, we have 4 federal courts of appeals even before RLUIPA saying this sort of cause of action for damages, that's not a thing under the spending clause. And so if
Don't we have a number of Supreme Court cases that allow for spending clause statutes to bind non-recipients?
Your Honor, I believe the only example you saw in the yellow brief was the Franklin case, where my friend said that the 11th Circuit had a pre-existing case on the books that controlled the answer.
What about Grove City?
Your Honor, I don't recall the history behind Grove City, but I guess what I tell you is that this is an extraordinarily unique context where you have federal courts of appeals on-point precedents both before and after RLUIPA's enactment that are unanimously telling any state operating within the regional borders of those circuits, this is just not a thing, and that's why.
So are you distinguishing Salinas, Sabri, and Dole? I mean, they were binding non-recipients, right?
Your Honor, I want to. resist the characterization of them as non-recipients, because I think you talk about recipients and non-recipients when you're talking about spending clause legislation. 666, all of those cases, that's not spending clause legislation. That's what this court said expressly at page 608 in Sabri. And so once you conceive of a statute like RLUIPA as spending clause legislation or not spending clause legislation, that's going to dictate which path, petitioner's given you, which path you choose. And that's what I'm saying.
Assuming that spending clause legislation matters. This is going back to the point with Justice Kagan. Assuming that it makes a difference that it's spending clause legislation, you say, then we can distinguish all these other cases.
I think it has to matter, Justice Jackson.
Even though we said it didn't in Tlefsky.
Your Honor, this is the only reason we're here today is because Congress used its spending clause authority to pass RLUIPA. Like, if it had never done that, we wouldn't be here today. And I think petitioner has the burden to tell the court either you use spending clause authority or you use the 666 path.
Spending clause legislation, it matters because that imposes a bar of clarity that usually is not imposed. So when we read the statute, we have to be cognizant of the fact that it was passed pursuant to the spending clause, and we have to say, is this clear enough? But that doesn't have anything to do with the questions that you're now talking about, because once we get to this constitutional issue, we've already decided the statute is clear enough, and the question is only, could Congress do this?
So I respectfully disagree with that, Justice Kagan, for this reason, which is Cummings reiterated that Congress only acts legitimately when it sends federal funds out and it gets a reciprocal promise to comply with conditions in return. Sure, you can say that that existed here as to the state, but you cannot say it with respect to the state official in his personal capacity. One, because he never received—
Yeah, but that's what I'm saying. That's always true with respect to 1983 suits, is that you can always say, oh, the state understood this, but the state employees did not. Now, in fact, that's not true as a factual matter. State employees are well aware that 1983 suits exist and that other federal remedies exist too. But the point that I'm making is that this RLUIPA is no different with respect to putting an employee on notice than a 1983 action is.
And, Your Honor, I think if and when this court gets a Section 1983 action
Jags.
where the underlying substantive
We can strike that down too.
Read that.
No, well, I think you're going to have a question, Justice
1983
Kagan,
suits are
about
civil
whether Congress
rights
could use
suits.
its spending clause authority to create the substantive right that runs against an individual person in his individual capacity. That's not a question the court has answered. I would say, if you eventually have to answer it, I think the answer is no, because that just is completely contrary to how this court has conceived of the spending clause and the contract analogy that undergirds it.
To the extent we're talking about the contract analogy,
Let me
an
know if the
agent
audio's out. Okay.
who knowingly violates a duty that the principal owes to a third party may be liable to the principal, but not to the third party, right?
That's correct.
And the principal, as a result of the agent's misconduct, may be liable to the third party as well.
That's absolutely right. In Justice Gorsuch, we have the example in the red brief of, the agent who signs a contract on behalf of the principal. Even if our state prison officials had signed whatever spending contract under RLUIPA you want to pick on behalf of the state of Louisiana, contract principals will say you're still not personally bound. That doesn't personally bind that
Bring
agent.
it in and out
And
so it doesn't block everything.
That's what we have here. It's somebody who's not alleged to have been involved in the spending process whatsoever. And let me make clear,
And whether Congress could provide clear notice and get consent from the employees, we don't have to decide that.
That's exactly right.
Whether that might be necessary and proper, and we don't have to decide that.
You could leave it for another day, Justice
No,
Gorsuch.
but how about if we don't want to? Give me your best answer.
But how about
Give me your best answer. As I'm hearing you, you're saying that they can bind the state by giving the state money, but they can have an abundantly clear notice. Every employee you have must abide by this statute. And if they don't, that individual
correct, Jags.
employee will pay damages. You're saying that's not adequate notice. It's not adequate notice if the individual signs a contract with the state.
there's a couple more steps in there, Jags, but
Because they didn't sign the contract with the federal government? Is that your argument
he
too?
got transferred
I'm not
from
calling-
one place
I'm
to
not quite
another, and when
following
he
that
walked
last part
into
of
the
the
new
question,
place,
Justice Sotomayor.
Assume
What I-
that the hypothetical that the other side put forward. They could have
handcuffed him to a
had
chair, and
the government say to the states,
They didn't really give him a
tell every
chance.
employee that they're liable if they breach, to us, if they breach this contract.
Yeah, there's definitely a difference.
So Justice Sotomayor, if Congress passes a statute that says, states, if you take our funds, every one of your employment contracts has to tell the employees that
How
they're
about states that don't have employment contracts? States who just hire you pursuant to a collective bargaining agreement, it's pursuant. Federal government can't say, you must tell every employee they're personally liable.
Any contract the state enters into, if the state is the recipient of federal funds and Congress says—
Will the individual be liable if the federal law is that clear?
Your Honor, I think Congress would have to tell the state, you have to flow down in those contracts all of these requirements, and then you get consent from whoever the contractee is.
So you want a piece of paper for people to know the law?
Yeah, because, I mean, under contracts, do you have to have it written down on a piece of paper? I thought you could make an agreement that didn't, that wasn't expressed in that way.
Justice Jackson, in a jurisprudence based on consent, consent has to mean something.
No, I understand. I understand. And the question I think that Justice Sotomayor is asking is, why can't that consent be demonstrated through the employment agreement? Whether the employment agreement has all the terms written down or not, why couldn't we have a situation in which Congress makes clear to the states that its employees need to follow the law or be held liable, individually in this way, and then the states contract with individual employees who understand, given that agreement that is, part of the law, that that's what they have to do.
So, Justice Jackson, I think in that hypothetical, you'd have a factual determination to make, which is what sort of notice was the employee on, what was written down or said in that contracting process.
And your view is only if the state actually writes the terms into the employment agreement would there be sufficient notice to the employee? Only if they write it down.
Justice Jackson, I'm not wedded to the method of the notice.
I'm just answering, I'd like you to answer that question. If they wrote it down, is your answer that yes, then the employee could be held liable?
If the contract says, by accepting employment, you're agreeing to abide by all of the terms of RLUIPA, which, by the way, includes money damages in your personal capacity, then yes.
But we can't imply that that's the case because there is a law that says that federal employees under this circumstance have to abide by RLUIPA.
Because that is never how the court has constructed the spending clause analysis. Justice
Thank you.
Jackson.
Counsel, thank you very much. Justice Thomas, anything further? Justice Alito?
Let me ask the same question that I asked the other side about the date. What specifically is the date we should look to?
Your Honor, it's the date that the state received federal funding. Now, in a statute like this, I will be candid that it is difficult to pin down because RLUIPA is agnostic about the source of federal funding. It says any federal funds that run, and so if you're talking about federal funding like Medicaid, which comes in basically monthly, weekly, that's the point in time at which you should look.
Thank you.
Justice Sotomayor? Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
You say RLUIPA does not unambiguously authorize a damages remedy. This is Justice Kagan's kind of bar of clarity point. The other side says the statute clearly authorizes individual capacity suits, so that traditionally has encompassed damages, and then they cite Tanzan on top of that. And I just want to make sure I have your responses to that precise point.
State employees, I think.
Sure,
that's
Your
the
Honor.
issue.
So a few things to say to that. I will say the one thing this court recognized in the Sosamon case is that even if you get to the appropriate relief question, there are a number of ways you can infer what that term means. So, for example, we laid out in the red brief the fact that the Congress referred to like injunctive relief with respect to the United States. There's different terminology like that. Another thing the court credited as plausible was that the ordinary definition of appropriate relief is typically particularly equitable relief, not damages. That's plausible. The other way I would attack that, Justice Kavanaugh, is remember what the court said in Sosamon and repeated in Tanzan, which is that the term appropriate relief is inherently ambiguous and context dependent. And I think the thrust of everything I've said today and what we say in the red brief is that the most important context here, at least for our purposes, is what constitutional authority was Congress using to actually enact this putative cause of action for damages.
All right,
that's the point that Chief Judge Sutton made, and I think that's exactly the right way to think about the relevant context here.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Tripp?
Will somebody send me a puppy kisses gift?
Just a few quick points. Justice Barrett, to start with the question about mini RFRA, this is in our cert reply. The state's mini RFRA departs from the compelling interest test for prison safety or security regulations, so it wouldn't provide any relief. And obviously, Congress wanted to have a nationwide remedy here. Justice Kavanaugh, to just respond to that last exchange, I hear no answer to the basic point that there's an individual capacity action. It is expressed on the face of the statute. And then as long as you just do what you normally do and ask what damages are appropriate in the context of individual capacity action, again, I still hear no answer. They're presumptively available under Franklin. That's an implied cause of action in a spending clause case, and they say damages are available, that's the norm. Tanzin explains, traces it all the way back through the history, and still there's no answer to the point that if you don't have damages in the individual capacity action, you get nothing. There's no such thing as an individual capacity injunction. It's the whole point. And again, if you don't have damages, like look at the facts of this case. But think about what Congress that enacted this law was trying to do. This is exactly where they were trying to have accountability, and I think it's clear as day on the face of the statute. I think a lot of the questions go to notice. There are a lot of questions to notice. The notice is baked in. They admit there's sufficient notice to the substantive condition. The remedial condition is the very next section in the statute. Like, I don't understand any theory of notice where as a state employee, you're bound by one page of the statute but not the next one. That doesn't make any sense. They are clearly on notice of both, and they are both here. It's the individual capacity action is clear as day, and then damages are just always appropriate relief in an individual capacity action, as every state prison official knows because they face these kind of suits all the time. This is the norm for them. And of course, you have an additional layer of protection on the notice side because qualified immunity applies.
No, just the puppy.
And of course, we have an extraordinary case where not only was there clearly established law, but we provided them actual notice of it, and they still violated it. I think really, at the end of the day, like I'm still hearing ultimately no answer to Salinas, the Salinas, Dixon, Hess, Laudani line of cases, and the crux of those cases again. The root of the power is that it runs consensually all the way down. There's contract, you take the job as a prison official, subject to as a law enforcement official in a federally funded prison, of course you take it, subject to the conditions that Congress has attached, and here has attached both of them. And I think really, at the end of the day, what the case is sort of fundamentally about is, has Congress actually succeeded in restoring pre-Smith rights and remedies? I think that's really the question. And I think there's no doubt that that's what Congress meant to do, and there's no serious doubt under this court's precedents that that's constitutional. So we're asking the court to reverse.
Thank you, counsel. The case is submitted.
All right, so that's one down. So Dana, it has to be if you do the puppy kisses one, because it's the only one with a dog. So if you do the puppy kisses one, it'll switch it. All right, so the next case, guys, is, and I'll write this up in a second on the thing, but it's GEO Group. So GEO Group runs private detention centers for immigration. Keep in mind, very, very important, not criminal, civil. So these are not punishment facilities. These are detention facilities for holding people. And there was a very similar case, almost exactly the same situation in Washington. They had two things going on there. One is that while you were staying there, while you were being held there, you had to clean not just your space, but everybody's space. And if you didn't do it, you could be put in solitary confinement. And the second thing is you were allowed to work. And that meant, doing the laundry for the place, feeding, running the kitchen, that sort of thing. And if you did voluntary work, you would make $1 per day, which means that this company, GEO Group, was getting paid by the government to hire regular workers to come in. They're like, oh, if we need to operate this place, we're going to need like 10 people to run the kitchen. Each one of them is going to need, minimum wage, so it's going to cost this much. But instead, they were paying people $1 per day to do that same work.
Mr. Dre?
So these guys are suing for
the government can act only through agents,
being forced to work
or
and being underpaid, unjust enrichment.
And the common law draws no distinction between public servants and private individuals engaged in public service. That makes sense. Contractors following the government's instructions are immune from suit for the same reason government employees are immune. That is, they are doing the sovereign's work. Now, to be sure, their immunity is not the same as the sovereign's. The sovereign is immune from suit unless it has waived its immunity.
Sovereign
Its
immunity, you
agents
can't
are
sue the
only
government.
immune when they
And
satisfy
these guys are
certain
saying
conditions.
they get,
The most
I
familiar
can't think of the
example
word right
is
now, but
government
like
employees
they also get
qualified
sovereign immunity because they're contractors.
For
which
contractors,
we'll see
the
whether they
conditions
do
for
or not.
immunity are most famously articulated in Yearsley. Namely, what was done was within the constitutional power of Congress, and the contractor performed in compliance with all federal directions. When those conditions are met, a private party doing the government's work is immune from suit. If, however, a district court concludes as a matter of law that those conditions are unmet, as occurred here, that holding is an appealable collateral order. The Yearsley conditions are dispositive of the contractor's asserted immunity and separate from the underlying merits. And because an immunity from suit is at issue, waiting until the end of trial and taking appeal only then is not an adequate alternative. Orders denying contractors immunity therefore fit comfortably within this court's precedent, permitting immediate appeals of any number of other immunities. The court should therefore reverse the 10th Circuit's dismissal of this appeal. I welcome the court's questions.
Could you cite show us the language in Yearsley that indicates that this immunity from suit and also the basis for that?
In two cases.
But Yearsley was just
it has two requirements. One is that
it's a short opinion.
they have to have given the power over to this contractor, and two is that the contractor has to follow the rules.
Which had gone to the Court of Claims, and that certainly that Yearsley, the construction company, could not effect a taking.
So Yearsley itself arises after trial, so the court doesn't have to engage the ability not to endure a suit.
Yeah.
But drawing on a common law history that includes the Piquet-Habana, Lamar versus Brown, and Murray's lessee, the court distills these two conditions. And although it doesn't say immunity, I'll concede that. 3 years later in Brady, the court says, of course, contractors obtain an immunity
last case, guys.
in connection with the work they perform for the government. And then in 2019, this court explained in Nick versus Township of Scott that Yearsley was correct to recognize an immunity from suit. And so this is a common law immunity case. And the long arc of common law cases, or as the court described it in Digital Equipment, there is a good pedigree in public law for the asserted immunity.
Why isn't Yearsley better understood as a defense than an immunity?
So this is a big question.
Well,
is this a defense
the court has,
or an immunity?
Consistently said that it's an immunity and an immunity from suit.
So this guy works for
rationales
Geo Group if
that
he's
this
saying it's
court
an
and
immunity.
others have given for it is because of the relationship to the sovereign.
If it's an
So
immunity, you can't
it's
bring
not
the
just-
case at all.
Sovereign
If it's a
can't
defense, then
delegate
you have the
or
whole case, and
give
then they get to
away
bring it at
their
the end.
immunity. And I thought the immunity really is unique to the sovereign. That's the essence of it. And it can't be sort of handed off to other folks.
The other side is
sovereign's
saying, no, no,
immunity is unique to
this
the
has
sovereign.
been
The
misread
sovereign's
all along. This has
unconditional
never
immunity.
been an
And that's
immunity.
Campbell-Ewald. That's what the court held in Campbell-Ewald, rejecting the rather ambitious argument that that contractor was forced to make because they had disobeyed the government's instructions, that contractor enjoyed the government's embracive immunity, as the court called it. And the court rejected that, as I note, because that's true. Your Honor is absolutely correct. The sovereign doesn't hand off its immunity. But there are other immunities, including qualified immunity, that are available to people who perform the government's work.
Mr. Dre, when your client claims this Yearsley protection, is your client saying, I satisfied the Yearsley criteria and that shows that I did nothing wrong? Or is your client saying, I satisfied the Yearsley criteria, that means that even though I did something wrong, it was in fact, I am in fact protected from legal consequence?
The latter. So in fact, immunities are only useful when they protect. Same thing with defenses.
Well, go ahead. Explain to me why it's the latter, because it seems to me that the Yearsley criteria suggests that you're saying the former. In other words, when somebody says, look, I did only what the government authorized by way of a lawful authorization, what I'm really saying is, so how could I have done anything wrong?
Oh, okay. So consider the Cunningham case from the Fourth Circuit that we cite, which Judge Floyd gives a great exposition of this doctrine. in that case, it's kind of like Campbell-Ewald, except the instruction was essentially violate the TCPA to reach out to people who had not consented to be contacted. That instruction would definitely violate federal law, but the Fourth Circuit quite appropriately applied Yearsley to conclude that the contractor was immune from suit because it was following the government's instructions. So that's why I say it falls into the latter category.
Well, I'm following the government's instructions, and the government's instructions are lawful, so obviously everything I did was lawful too. Isn't that the sort of rationale of Yearsley?
No, Your Honor, and this is an important point. My friends on the other side rewrite Yearsley's first condition to say, was it lawful? That has never been announced as the first Yearsley condition. And it doesn't make any sense to say that you enjoy an immunity or even a defense or even a derivative privilege or whatever the SG's office has for us.
Did the government
that doesn't make any sense
authority?
if what you've done
Two,
complied
did
with
the
the law.
contractor
The
follow
value of an immunity, and again, the Cunningham decision, to which I commend to the court's attention, does a great job of analyzing this. It only does any work if the person could have been liable. So the government's instruction may have been violate the TCPA, consider Campbell-Ewald, but change one of the facts. Suppose they had said, the Navy had said to the contractor,
I wish I had time right now to give you the whole
carpet bomb
speech
every
on
18
sovereign.
to
It's
24-year-old in America
really,
with a
really
text
fun.
asking if they'd like to join the Navy.
In theory,
in that case,
sovereign, there's
the
all kinds of
contractor in
arguments about
Campbell-Ewald
what is
wouldn't
the
have
sovereign.
had to make the argument that
the
it was
top.
entitled to the government's absolute immunity. It would be able to argue that it was following the government's instructions and comes within Yearsley.
It wouldn't get the Yearsley defense, though, because I thought the government would have to have the authority to issue the instructions, and to the extent the instructions violated the law, they wouldn't be authorized.
Well, no, the question is, was it within Congress's power to authorize? And Congress—
And it's not in Congress's power. Are you saying it is within Congress's power to instruct its contractors to do something unlawful?
So the question, I want to be very precise about the language, Your Honor. The question in Yearsley's first prong is whether what was done was within the constitutional power of Congress.
Understood. Does Congress have the constitutional power, to authorize the government to direct its contractors to do something unlawful?
That's a slightly different, but importantly different question, so please indulge me on this. The question is, could Congress have done the thing? So could Congress have carpet bombed all the 18 to 24-year-olds with a text? Definitely yes. It's a constitutional check. In other words, it's an anti-circumvention prong in the first prong of Yearsley. Was what was done, say, we'll just keep using this example from Campbell-Ewald, what was done, texting everyone in America, was that within the constitutional power of Congress? Absolutely. The question is not, does Congress have the ability to do that, to authorize its contractors, for example? It's was the underlying action within Congress's authority.
You're skipping a big step. Yearsley was never an immunity case, not because it was after trial, but because the issue in Yearsley was who was responsible for the taking. And what we said is the agent was not responsible, it was the government. He was acting at the government's direction. The government can take, so sue the government, all right? That's what we said in Yearsley. The fact that we've inartfully called it an immunity, it's really a question of relief from liability. That's all Yearsley was about, was saying, you, the agent, is not liable, the principal is liable.
And that would be a defense,
so I don't know why
not
the
an
reliance on, or even claiming this is an immunity defense. But putting that aside, you're taking a step further. You're taking what the Yearsley court said, it was, was what the government did lawful? Congress can pass a law that permits the government to send texts to 16-year-olds. But if it passes a law that says our military, no one can send a text, including our military, then I don't think that the military giving an order to its contractor to do it gives the contractor immunity. It may give it a defense to liability. I'm not sure what that defense would be, because Yearsley said you have to be following a lawful government order. But this is circular to me.
I think what Your Honor is asking is, what if Congress passed something that was outside of its constitutional authority, like no one shall text anybody? If that was the instruction, say to
It's
a
a question
satellite
of when,
operator,
how
that was a
far you
government
can
contractor,
take the suit.
just jam all the text, don't
Muddy.
let people communicate or speak
Because
with
these
each other.
guys wanted to,
There'd be very good
they don't
argument
want the
that is
suit to go
outside of
any
Congress's
further.
authority
They want to be
to
able to shut it
authorize
down
because
on
it
day
can't
one.
shut down speech. Great.
And we're back to
Because they don't
yours,
want to go
then.
through,
Can
they
the
don't want all this
contractor-
stuff out in the open. They don't want to
Who should-
produce
who
discovery.
should
They don't
be
want anybody to know
responsible
what's
for
going
that
on.
loss? Then but that's still a
And
liability question.
they
not-
tried to
No,
shut,
it's
they
not.
don't want
I mean,
this suit to happen
so
at all.
Throughout the history of this,
Even
this
if
body of law,
there's
the
no
court has
liability at
consistently
the end,
emphasized that it's avoidance of
this would
suit,
allow
that
the
it
suit
is,
to go all the
an
way
immunity
through,
from suit.
find
And
guilt, or not
that
guilt,
is
but
different, of course, than
find
just
that
avoiding
they're
liability.
liable,
Now, the other
and
side
then
cites a
when
number
they're
of times
deciding how
where
much
the
they're
word
liable for,
liability
maybe
appears
it's not
in this
much
court and other
because
courts' decisions. So,
they have a
for
defense,
example,
but
the Newman
they
case,
still
which is the
get
New York
hurt.
subway case, and Sally Oat are two that we talk about in the papers. They excerpt the word liability, but liability is avoided by both a defense and an immunity. So that doesn't tell you enough. But if you look deeper at those cases, you can see, and I think it's page 28 of the reply brief, you can see why the reasoning is, in Newman, for example, the court says, because the contractor stands in the shoes of the government, it has all of the immunities that come with being the government's doing the government's work. And in fact, Yearsley and Brady
Derivative
say
sovereign
that. They cite
immunity
United
is the
States
phrase.
versus
I'm
Lynette
sorry, I
to
couldn't
say
think of the phrase.
the action of the contractor is the action of the government.
Thank you, counsel.
the argument is
So
that that doesn't
with
exist.
that in mind, the operative question
That
then
would be
becomes
something
whether
kinda
you
new.
have a collateral order that follows from this immunity. And in that regard, the court's precedent is very helpful. Puerto Rico Aqueduct expressly says that it follows that you have a collateral order when an immunity from suit is
These
at
are
stake.
attorneys for Geo Group, which is a
Filarski and other
private
cases have
contractor
teased out the purposes, including Mitchell, for
that
which
brings-
immunities
that
exist. And
Why is the government on the
runs
other side from you?
detention,
I mean, that seems
immigration
like a
detention
big,
facilities.
it's a good question.
Big hurdle, and it's been that way.
Yes,
GMB.
well, it's been that way lately. So as I read the government's papers in this case, it is the reason that they're on that side is their legal conclusion about what's at stake. That is, whether it's an immunity or, as they have posited for the last 8 years, but not before that, whether it is derivative privilege based on these sort of principal agency concepts. The government, to its credit, acknowledges that the impact on government operations from exposing its contractors to massive liability would be a significant obstacle. I think it's page 31 of their brief, and that Yearsley is critically important, page 3 of their brief. So I think we're aligned as to part of the point, but I'm aware of the seating chart, and I think the explanation is that they have this rather creative argument based on principal agent concepts, which in 1939 in Yearsley, they told the court that it was obvious as a matter of principle that contractors were immune. In Filarski, they said the same policy considerations apply. And then last week in Hinckley, it's page 10 of their amicus brief, they characterized Yearsley as barring suit. So I think it's a break from where they've been in the past, and as a result, Wythe versus Levine was the same situation where the government had changed positions. It's also wrong on the merits. I mean, it proves too much and too little, as we point out in the reply brief. Too much in that...
they say also that, I don't want to interrupt you there, but just so you can fold this in, they say there are other avenues for you for relief from this issue to be pursued.
Yes, and I can fold that in, because it proves too much in that employees who get qualified immunity and officers who have their own immunity, absolute immunity, also could avail themselves of 1292. And one of the odd things about the government's position in this brief is that it carves out a new and special rule unique to federal contractors that they have to go through 1292B. Nobody else has to do that involved in the process. So whereas in our case, you have GEO, for example, running a facility, and there are a number of ICE personnel. I think we have to provide 14 offices for ICE. There are 2 immigration courtrooms at this facility. Everybody involved, the ICE officials, the sovereign itself, are all immune and can all take a collateral order appeal. But the contractor, who is just doing what they're told, at least that's the presumption here under the second prong, is unable to appeal the denial of its immunity. So it creates a very odd loophole or gap in the operation of these programs.
Can I just ask you, because it does seem to me that the core of this is how we characterize Yearsley. Is it a defense or is it actually conferring immunity? What do we do with the fact that in Yearsley itself, the government had waived sovereign immunity? That's my understanding. And so to the extent that that's the case, wouldn't we have a very odd scenario in which the contractor would somehow be given immunity, but the government itself wouldn't, even though you say the contractor's immunity is derivative of the government's?
This illustrates exactly the way it's supposed to work.
Okay.
So the sovereign waives its immunity in that case and accepts liability, as it must constitutionally for a taking, by the way.
Right.
But then you sue the federal government. Our friends on the other side haven't sued the federal government in this case. The whole game here is suing contractors to try and thwart the government's policies. And so, today, today it's a case about immigration detention. Tomorrow it could be Cunningham, in which the contractor was engaged in signing people up for subsidized insurance under the Affordable Care Act. If you name a government policy or program, it will rely on contractors, and I can find you somebody who would like to stymie the implementation of that program. So that is how we get back to the important interests at stake here. But to your Honor's question, the government is free to immunity all it wants. The question, however, under the common law, and the long common law tradition, is that when contractors are performing as directed, that they are immune. And that makes sense. I mean, you should actually want to focus the litigation on the decision maker.
No,
which
I
is the
understand, but you can do that by treating it as a defense. It's just odd to suggest that in a derivative sovereign immunity kind of, that there is derivative sovereign immunity in this kind of circumstance. I mean, yes, to the extent that the contractor is saying we were just following orders, the law provides an opportunity for them to defend themselves as a result of that, and I thought that's really the crux of what Yearsley is getting at. But as Justice Kagan said, that's a different concept than we should be liable, we are liable, but we are not going to be held liable because we have immunity.
It is a different concept, Justice Jackson, and it's an importantly different concept because qualified immunity could be a defense.
No, but it's an odd concept in a world in which the government has assumed liability.
So sometimes it has, sometimes it has and sometimes it hasn't. In this case, the government has not waived its sovereign immunity as to the administration of these programs, which is why they've sued us. The government runs the exact same programs at its facilities. It's Section 5.8 of the PBNDS, which is the voluntary work program. Congress appropriates exactly the stipend that GEO pays. It's at PEDAP 141 and 144 is the disciplinary scale that comes from the government. It applies to their facilities too. So all of these decisions are made by the government, which is why I think Your Honor makes a good point that the suit should be directed against the government.
That still gets back to why is the government, I guess I'm just stuck on this. You said this is across all sorts of government programs, obviously agree. Why is the government then taking a position that you say will thwart the implementation operations of all these government programs? I'm just not seeing that, and because they're on the other side, it casts doubt on your assertion that all these programs are going to be, obviously we're going to ask the government this too. But.
I was going to suggest that you ask Dr. Joshi that very question. And it is to some extent better directed to him. All I can say is that, what's driving their brief, as far as I read it, is this reconceptualization of the long common law history and the idea that, in fact, what this court and others have been doing, but never saying it, is applying some sort of derivative privilege born in the pages of the restatement, and urged, by the way, on this court in Campbell-Ewald, and the court didn't take the bait, urged on the Ninth Circuit in Childs, the 2022 decision, that court didn't take the bait, repeated here in the CVSG brief in CACI from a few years ago. No one has embraced this thing, and it's not new. Well, it's somewhat new. It's 8 years old. But before that, the government was consistently on the side of its contractors. And again, beyond that, I just have to leave it to the government. If the calculation is about the burden imposed on contractors, the government doesn't really have a perspective on life as a private litigant. they don't have to hire outside counsel.
But couldn't you negotiate for that in your contract with the government, that they cover your litigation expenses?
No, I wish we could. So the Anti-Deficiency Act, of course, prevents us from having an open-ended indemnification. FAR 31.205 prevents any number of litigation costs from being built in. This is a fixed price contract, as all of these are.
Well, couldn't you fix that into the price of the contract?
No, because the FARs exclude. Very fair question. The FARs exclude these litigation expenses, and if we were to put them in as sort of like overhead or something, that would be a false claim and would expose us to a suit under the False Claims Act. So there again, although it is a real problem for GEO.
I just want to make sure I understand what you're saying. You're saying you cannot price in litigation risk?
Correct. We cannot price in, at least not all litigation risk. It may be possible in some contracts, Your Honor, but as a general proposition, again, it's FAR the Federal Acquisition Regulations, Part 31.205, that greatly restricts our ability to price that in. And as a result, you know, the government and GEO cite the Nawazar case in the Ninth Circuit, where the state of Washington sought to impose its minimum wage law on GEO's operation of the voluntary work program.
They succeeded.
The Ninth Circuit said that was A-OK, cert petition coming. But the government, in the meantime, suspended, as Judge Bumate noted in his dissent from denial, suspended the operation of the voluntary work program at that facility. The point here is that it's not strictly monetary, Justice Barrett. This also goes to the operation of policy. That is the ICE determination that having a voluntary work program that reduces idleness and encourages cooperation and reduces disciplinary incidents is a good penological policy, has been suspended at that facility exclusively because of the crushing liability that's coming for the contractors.
Counsel, it seems to me like all of the arguments you're making, I can see why you want them, and there's a lot of functional reasons why it might make sense, advanced government interests, et cetera.
These guys operate.
But should they be directed to Congress? Because at the end of the day, we're not being asked to decide whether you should have a defense to liability. We're asking whether this is
people that stay there $1 a day to run the kitchen, to run things like that.
An immediate appeal, and so Congress
that's
could
a
give
good thing because it keeps them from being
yes,
idle.
Yes, they could. Congress
but this is not
could
a
have
punishment
given
facility.
Employees an immediate appeal, the president an immediate appeal. So I take Your Honor's point. It is certainly possible. But again, this goes to this is analogous to the 1292 argument that the government puts forward. It would be new ground and a new contractor-specific rule to say that some people who do the government's work and some people who are immune have to go through an additional step of obtaining statutory authorization.
Well, we have certain statutory limits, and one of them is the finality rule. So you're asking us to make a judge-made immunity, which is an odd fit because sometimes the government has immunity or not. You don't care if the government has immunity. You're saying we have immunity, so we're creating a new sort of immunity. A judge-made exception to finality, after we've said which should be sparingly used. And a judge-made exception to Congress's legislation over immigration and government contracting. So you're asking us as judges to make 3 immunities, 3 new principles.
Not at all, Your Honor. The court has already made the immunity in question. It stretches back to the cases that Yearsley cited, which, you know, Yearsley's 1940, those street
release. We've always said the sovereign can't contract away its immunity.
And respectfully, that is
immunity or it's either a defense to liability.
Not at all. So that is what we call the grand straw man. No one is asking for the government's embrace of immunity. Employees enjoy qualified immunity. That's not the government giving away its immunity.
Qualified immunity is different, isn't it, in kind? I mean, qualified immunity has different purposes than this.
Not at all. So Filarski answers that question. Filarski says expressly that this serves, that immunity for contractors serves the identical purposes. That is to say, not dissuading good people from serving in government, avoiding timidity in the exercise of discretion.
But it's not about individual officers in being shielded from undue interference with the performance of their duties
so
in the way that
there are 2 different programs here. One is the voluntary program, where they get paid $1 a day to work in the kitchen.
No liability
Other is
for
the required
contractors
program
who are following
where they have
the
to
government's
go
instructions.
clean
the qualified immunity is almost
room
the opposite. It's like
or whatever.
when you do something wrong, you are immunized.
If you don't participate in the
if it's not clear to you that
cleaning
that
program, you
principle
can get
exists
put
in
in
the law and
solitary
that you were doing
confinement for up
something
to a
wrong.
week.
This is the opposite of that, I think.
No, I wish we got qualified immunity. Qualified immunity is much easier to satisfy because the question is, did you do something illegal? Well, was it clearly illegal? Those conditions are more forgiving than the ones that Yearsley gives to contractors. And believe me, I would love to have fit this within qualified immunity.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Kagan? Any further?
One of the things to note here is that
Thank you, counsel.
in the Fifth Circuit, or Fifth, 10th, whatever circuit brief, they found that they did not, or I
Mr.
think
Chief Justice, and may it
one of the
please the
courts
court,
found that they did
to
not
justify
follow
an expansion of the
the
collateral
orders
order
of the
doctrine,
government.
GEO has to run the table. It
And
must
GEO kind of made
demonstrate
these
that, as we
programs
just
up.
heard, Yearsley is the rare defense that provides a right to avoid
They
litigation
used like
entirely.
some ideas that the government gave them
That
and blew them out. made
immediate
them
appeal serves a public
bigger.
interest so important that it overrides the final judgment rule. And 3, as a category, Yearsley orders are completely separate from the merits. GEO fails on all 3, each of which is an independent basis to affirm. First, on the right to avoid trial. Below and in its opening brief, GEO claimed that contractors that satisfy Yearsley's requirements share the sovereign's immunity. It has now disavowed that claim. I think that's correct. But that means that all GEO is left with is the claim that Yearsley is qualified immunity for contractors. But qualified immunity is qualified immunity from contractors. What Filarski shows is that where history and policy support immunity from suit, those who work for the government get qualified immunity, which means GEO's argument boils down to the claim that Yearsley is an immunity from suit for contractors who can't show that history and policy warrant immunity. That doesn't make sense as a matter of common sense. It's also not what Yearsley says or what the history of the defense that Yearsley recognizes shows. Second, on effective unreviewability. GEO argues that immediate appeal of all Yearsley orders, whether they apply to detention contractors or tree trimmers, is necessary to avoid burdening the government. But the government itself disagrees, and this court held as much in Will. And finally, on separateness from the merits, unlike qualified immunity, Yearsley cannot be granted without answering fact-intensive questions. What did the contractor do?
Yes, this
what
is
did
live.
the government direct? And what caused the plaintiff's injuries? So ordinarily, Yearsley orders merely decide whether there's a sufficient factual dispute to send to the jury. Precisely what this court in Johnson held cannot be immediately appealed. I welcome the court's questions.
This is the. Should
If
also
we
get into
agree
the other
with
question, which
you,
is this collateral.
what approach
like
should we
basically,
take in
you can't appeal a
disposing of this?
You
So
can't
I think the
appeal
most
a
straightforward
question
approach
if it's
is
not like
to
a final
hold,
decision. If it's
GEO's
not like a
entire
bookend.
argument rests on this contention
And
that
they said when
Yearsley
they
is a right
said
to
when
avoid
you decided
trial.
we didn't have
I think
immunity,
it's
that was a
clearly
bookend.
not
We
if
should have
you
been
look
able
at
to
Yearsley
appeal it
itself, and if you
immediately
look
and
at the
not
history,
gone
I think
forward
the
with the case.
most straightforward approach is to do that. But I think second would be to rule on the effective unreviewability prong. The
And they're
sole
like, no.
interest that GEO is
They- it's
claiming
called
here that
collateral-
supports a right to immediate appeal is the interest
The
in
collateral order
avoiding the
doctrine, which
burdens
says
of
that
litigation to the
sometimes
government. That's
things that aren't
precisely
quite
the interest
bookends
that
can
this
still be
court held
bookends
in
if
Will
it's something
versus
like
Halleck
immunity.
isn't
And
enough.
that's the
In
other
that
argument
case, you'll
here.
recall that's the case about
Whether
the
or not
Federal
they have to go
Tort Claims
forward with
Act
the
judgment
case.
bar. In that case,
Because
the defendants were
immunity versus
government
defense is a big
employees,
enough
and it was a
question that they should be able
statute
to
that
appeal
said no action can be brought at all. So you have a statutory immunity from suit with a government employee defendant, and this court held that the burdens of litigation are not enough. So I'll take each of those. So first, to start with the questions on the right to avoid suit that this court was discussing with GEO's counsel. As I take it, they have essentially two arguments. One is this loose language argument. There's some language that we could interpret in cases that weren't dealing with this issue that suggests it's an immunity from suit. I'll note that none of those cases, and in fact none of the briefs that GEO cites actually says that, except with one exception, which is the footnote in Nick. If you read the next sentence in the footnote in Nick, what it says is, the Tucker Act provides a complete remedy, so it excludes liability. So like Brady, Nick also said, makes clear what it means by immunity from suit, and again, the court wasn't dealing with that issue. And if this court, as this court said in digital equipment, virtually every right that can be enforced on a motion to dismiss can be loosely called, and in fact, I'll tell you, has loosely been called an immunity from suit. If you look at statute of limitations, if you look at personal jurisdiction, if you look at Monell, which held that a local government may not be sued for an injury inflicted solely by its employees and agents, so that's the language may not be sued. Still in Swint, this court held that government entities don't have a right to avoid trial under Monell. So over and over again, this court has used this kind of loose language. But what the court focuses on is what is the core of the actual right? Is this actually a right to avoid trial? And if you look at the cases that Yearsley cites and that discuss this government authority defense over and over again, when the court is actually examining this defense, it says it's not a right to avoid trial.
What about Campbell-Ewald?
So Campbell-Ewald, I think, didn't answer this question. It didn't need to. It was after final judgment. The contractor there said there's this thing called derivative sovereign immunity, which I'll note Campbell-Ewald puts in scare quotes throughout the opinion. There's this thing called derivative sovereign immunity, and we get it. And what Campbell-Ewald said is, well, there's nothing to support your claim that there is this thing called derivative sovereign immunity. And in any event, everybody agrees that whatever it is, it would have these two requirements. And it said, at this stage, we can't determine that both of those requirements are met. And so I don't know that this court didn't actually have to decide the right to avoid trial versus immunity from suit issue. When it did look at that issue, so for example, Hopkins versus Clemson, what it says, and this is a quote, agents acting for the state, though not exempt from suit, could successfully defend by exhibiting the lawful authority under which they acted. Murray's lessee distinguishes the immunity from suit for the United States. Murray's lessee, though no suit can be brought against the United States, it says a suit may be brought against a marshal to provide its lawful authority. Brady, again, says, in broadening the government's use of contractors, so Brady considered essentially this argument, which was the government is using contractors all the time now. Shouldn't they be treated like employees of the government? And what Brady says is, in broadening the use of contractors, quote, immunity from suit is not favored. And what Brady says is, it would require not only a grant from Congress, but a grant in unambiguous terms. And there are numerous other cases. United States versus California says the same thing. So then,
But when GEO is doing exactly what government officials can do and generally have done, running facilities like this. So imagine you had brought these claims against ICE and specific ICE officials. ICE and the officials could raise sovereign immunity, they could raise qualified immunity and Westfall Act immunity. And if the district court denied any of those, then they could get an interlocutory appeal. So why shouldn't the rule be the same for GEO? Don't the considerations that justify interlocutory appeal when the suit is against a government official also justify an interlocutory appeal here?
I think it depends on the basis for the suit and particularly in the basis for the defense. So the reason that an ICE employee, and I'll note this court has never held that qualified immunity is a defense to forced labor claims, statutory forced labor claims, but I'll bracket that, assume that ICE employees could get qualified immunity or could assert it. The reason they can do that is what this court has said is that the history and the policy support an immunity from suit. And so if the history and policy support an immunity from suit, then you'll get qualified immunity. And what Filarski
All right,
says
well, how about the policy? Why isn't the policy the same, policy considerations the same here?
Sure. So what Filarski and what Mitchell say are the policy considerations that specifically justify the immunity from suit is the consideration of wanting government employees to show initiative in the face of unclear law. That is why you would get qualified immunity. That is not why you get Yearsley. Yearsley, in fact, is precisely the opposite of that. Yearsley only applies when you're doing exactly what the government directed, and it doesn't matter whether it's clearly established or not. Yearsley isn't about saying, contractors, we want you to go out and take bold action, regardless of whether you know it's lawful, regardless of whether you've been directed by the government. And so
But it's not really, the justification for qualified immunity is not just that you want government officials to be able to take bold action. It's that you don't want them to be to have to bear the burdens of litigation, which can be quite substantial, when it may well be that they didn't do anything that was unjustified based on what they knew. So why doesn't that apply just as well here? Those policy considerations, why don't they apply just as well here?
Sure. So I want to distinguish between the policy considerations that underlie a potential defense, like qualified immunity. Those considerations go to the existence of the defense. What Mitchell said is the key to qualified immunity that justifies an immediate appeal is this need to show initiative, and that's just not at issue in Yearsley. And we know that not all government defenses are immediately appealable. Not everything that's going to put a litigation burden on somebody who works with the government is immediately appealable. We know that from Will versus Halleck, the FTCA judgment bar claim. We know that from Swint, which held that Monell claims when a local government is when a plaintiff is trying to hold a local government liable for just the acts of its employees when they haven't satisfied Monell, Swint says no immediate appeal, and that is the government itself. McDonald reaffirms an old Supreme Court case about immunity from prosecution for people who have testified on behalf of the government. The public authority defense in the criminal context, which this court mentioned in the Trump case, that's a defense for people who work with the government, and this court said it's not an immunity from suit, it's a defense, and it's not immediately appealable. And so when we're talking about just the general costs to the government, what we're talking about is something that this court over and over again has said does not justify an immediate appeal. You need something special. And I'm happy to talk more about that, but I also want to flag that everything we're talking about now is policy. And and policy based on empirical questions. How much is this going to cost the government, if anything? What is the impact going to be? We have the government here telling us that the impact doesn't justify an immediate appeal, but if this court thinks that those kinds of considerations might do so, then the proper avenue for considering them is rulemaking, where you can get expertise from the bench and from the bar to explain these empirical questions, to discuss the policy considerations. Because here you have a case.
Well, policy is a dirty word, but isn't something similar to policy what is going on in Mitchell and in the other cases where we have said there's a right not to trial unless a certain requirement is met?
I absolutely agree with that, Your Honor. And Mitchell was before Congress passed a statute enabling the court to create new categories of interlocutory orders through rulemaking and interpret the final decision rule through rulemaking. And what this court has said in Swint, what it said in Mohawk, what it said recently in Microsoft is that now is the proper venue for answering this kind of question.
Hello.
Unless we've previously said that something is a collateral order, if we're going back and forth about empirical questions and policy questions, rulemaking is the proper venue for doing that. And then I'd like to just briefly address the idea, the completely separate from the merits prong. Again, what this court held in Mitchell is that the thing that makes qualified immunity collateral is that this clearly established law question. And that question is a purely question of law. And we know from Johnson that where you don't have that pure question of law, where you have a question that is there a sufficient dispute of fact to send to the jury, you don't get an immediate appeal. And the way, and I think Gio's argument on this point, as I understand it, is Mitchell held that any time you can answer any questions on given facts, that's sufficient.
This is again about whether or not they were allowed to stop what they were doing and go straight to appeal.
Any order on a motion for summary judgment, the issue in Johnson itself would have been immediately appealable, and we know that's not correct. What makes qualified immunity different is the question, you have to look at given facts to figure out what right is the plaintiff saying is violated here. But the fundamental question is interpreting Circuit and Supreme Court precedent to figure out whether a legal right was established at a particular time. That's the ordinary thing appellate courts do every day. Here, there is no equivalent on which Yearsley can be granted to this just interpret appellate and Supreme Court precedent. To get the Yearsley defense, a contractor always has to satisfy the second prong, which is, was the conduct that caused the plaintiff's injury directed by the government? And that is always a factual question that's record intensive. The question is, look at the facts underlying what the contractor did and what caused the plaintiff's injury, and then compare them with a second universe of facts, which is what the government directed, which I'll note is not just in the contract often, but is in handbooks, it can be in emails, it can be verbal, there can be deposition testimony.
Why does that question have to be answered in the context of Yearsley? In other words, your friend on the other side suggested that the Yearsley defense is just, or at least one prong of it, is not really about whether this conduct is actually lawful or whether or not this comports with the law, but just whether Congress had the constitutional ability to authorize it.
John, this case.
Sure. So I'll answer that question, but just to flag, Gio's argument on that, whether it's right or not, is just to the first prong, and so you'll still always have the second prong, which is what did the government direct the conduct that caused the plaintiff's injury. So in order to get Yearsley,
fact-bound,
you'll always have to answer this fact-bound question that's often going to be intertwined with the merits. But to answer your question directly, the reason Yearsley says, was this within Congress's authority, is because Yearsley involved a statute. The work that was being done by the contractor in Yearsley was directed by statute by Congress, and so to determine whether the government had authority to direct the contractor to do that, you're looking at Congress's authority. I am aware of no case that suggests that a contracting officer in an agency somewhere could authorize a contractor to violate federal law, and that would be validly conferred authority. And I think, the cases, I think, show otherwise. Yearsley itself, the reason it looks at whether the government provided a remedy for the taking was to determine whether the authority was validly conferred. And just to address the idea of agency principles, where this comes from, I take Gio's argument to be, well, these cases don't use the word privilege. That's true, most of them don't. But the restatement says privilege. What it's saying is a validly conferred authority. That's just the restatement's word for that kind of authority. Whether the principal had the lawful authority to do something that would otherwise violate the law and had the authority to confer that. And you can see that throughout this court's cases, starting with Yearsley. Yearsley itself couches its rule in terms of agency. And there's no dispute that the principles it applies are longstanding agency principles. In fact, Gio's opening brief says, Yearsley reflects settled agency principles. That's page 16 to 17. And this is most clear, I think, in Larson, where this court summarizes its jurisprudence on this. And I'll just read you a little bit of Larson. It says, the principle that an agent is liable for his own torts is an ancient one. It applies even to government actors. And then it says, if the actions of a government officer do not conflict with the terms of his valid statutory authority, then they are the actions of the government, if they would be the actions of a private principal. So Larson is saying, when a government agent takes an action, what you look to is traditional agency law, principal agent, to figure out whether that's the act of the government. And then it also says, even if the action is the act of the government agent is still liable if his action is such that a liability would be imposed by the general law of torts. In other words, we're looking at the general principles of torts, which include agency, of course, to figure out when is the government agent liable. That's what this court said in Larson. And that principle, that ordinary principle from the restatement, from Larson, from Yearsley, from Brady, that ordinary principle is if the principal has authority and validly delegates it, the agent is not liable for complying with directions. And because it comes from agency, that's one way you know that it's an ordinary defense. This court in Will versus Halleck said, this judgment bar, it's not exactly one-to-one with ordinary preclusion principles, but that's basically where it comes from. And we know preclusion we're not going to give an immediate appeal to something like preclusion. The same is true here. We don't ordinarily give an immediate appeal on the defense that my principal told me I could do this. And there's no reason to do so in this context.
Thank you, counsel. Justice Thomas? Justice Alito?
Just, Capital. Thank you, counsel.
Oh, my. I'll leave you with Obi for 1 minute.
Mr. Joshi?
Thank you, Mr. Chief Justice, and may it please the court. It sounds like the court has a pretty good handle on the issues, so why don't I just start by addressing why are we on this side of the lectern instead of the other. You know, the bottom line is that we just look at Yearsley and everything I think we said in our brief there. We said a suit can't be maintained. We're talking about liability. We look at Yearsley. We do think it's a rule about liability and a defense to liability, and then we're just trying to be faithful agents of this court's collateral order jurisprudence, which suggests that when you have a standard defense to liability, even if it's important, even if it would mean that you have to suffer through a trial that, had the motion to dismiss been granted, you wouldn't have had to suffer through, that is still not the kind of order that is immediately appealable as a final decision under Section 1291. And to be clear, we agree with petitioner that the defense is critical to our efforts, and a lot of what petitioner says in its briefs and a lot of what its amici say about the cost of liability and what that can do to the amount the government has to pay for services, we agree with that completely. We do think this is a really important defense, and if the defense were up here, we might well be on the other side of the lectern. But the only question here, as Justice Barrett indicated, was just the collateral order question, and there we think the right answer under this court's case law is that it is just like a denial of any other motion to dismiss on the merits. It's not immediately appealable. You have to wait until final judgment.
You should never over, oh, I'm sorry.
No,
No, please.
I was simply going to ask the question I asked earlier. What's your preferred method of disposing of this?
We think the right way to dispose of it is largely what my friend said for respondents, which is that because Yearsley reflects a defense to liability and not an immunity from even standing the burdens of trial, that it doesn't satisfy the third Cohen condition if you want to look at it doctrinally like that, and that's the most straightforward way to proceed.
I was just going to ask, you know, we know that this is a defense from liability as opposed to a true immunity, because why?
Because we view Yearsley through the principal agency concepts, in which we do think it's a privilege that's being delegated, but we really think if you look at the substance of what's being delegated, it means that the contractor acts lawfully when it obeys lawfully delegated instructions from the government. And we agree with respondents and what my friend said earlier, which is that an agency doesn't have, like a federal agency, doesn't have authority to violate a federal statute, for example. That's just not something an agency is allowed to do. So I don't think petitioner is correct to say that the first condition of Yearsley is just whether it's within Congress's constitutional power. Of course, Congress could pass a different statute, but it hasn't. It has passed a certain statute, and an agency is not free to violate it. And I don't think the agency is free to effectually violate the statute by simply contracting a private party to do it for the agency. That doesn't really make much sense. So we think where Yearsley applies, we think the first condition of Yearsley is really about lawfulness. Could the government lawfully do it? And then second, did the government lawfully delegate that privilege to the agent? And that's why we think there's really no gap between successfully showing entitlement to the Yearsley defense and having acted lawfully. We think those Venn diagrams are just circles on top of each other.
Mr. Joshi, is it true that a contractor can't price in litigation risk or seek indemnification for litigation expenses?
Yeah, we don't think that's quite true for a number of reasons. Number one, we do think they can, to the extent they have litigation costs in the background, they have their own in-house counsel, things like that. Those do go into sort of overhead costs, and I think most contractors, with all of their overheads, will, to a certain degree, price that into their bids, into the contract. And that's generally considered okay.
Ridiculous.
Also considered okay under the FAR is insurance against litigation costs. Those can be a line item in say, a cost-plus
Insurance,
contract
right.
that could be validly put into
Reagan,
a
did
bid,
you
and the
bring up
government could
somebody brought up
validly pay
insurance?
it. As far as indemnity goes, OLC has long taken the position that indemnity clauses are acceptable as long as, number one, they are capped, and number two, they are conditioned expressly in the contract as being contingent on there being appropriated funds available at the time the payment is due. So as long as those conditions are satisfied in the contract, even indemnity is okay. Now, I know that petitioner in the reply
On your
briefs-
first point, you mentioned, your friend on the other side mentioned the False Claims Act. That's not a concern?
I'm not entirely sure why it would be a False Claims Act violation to say in a contract, here are our overhead costs, and government, you can accept our bid or not.
Okay, well, I'm sure that'll be used in the future.
Well, I'm just not sure what Mr. Dre is referring to be honest. You know, in my own discussions with my client agencies, I've been told that these kinds of overhead costs typically are just reflective of background costs, and so presumably GEO might be competing with Core Civic, might be competing with others, and presumably if there were large litigation costs as a result of not having an interlocutory, or I shouldn't use the word interlocutory, but not having an immediate collateral order appeal, that would be the delta, presumably. I guess that would just be priced into the contract.
Can you hear that?
We don't see a hesitance on the part of either petitioner or Core Civic or other private contractors in bidding on contracts in circuits, including the Ninth, which is a pretty large circuit, that don't find this to be a collateral order subject to immediate appeal. As we note, to the extent you're thinking, well, maybe it is an immunity from suit, then you would have to answer the question from Will against Halleck, is this important enough to warrant an immediate appeal? Is this more like in digital equipment, in LoRo lines, in Heike, you know, in other cases? You would have to ask, you know, is this right being under-enforced, was the word Mohawk used? Are district courts getting it wrong a lot? We don't see evidence of that either. All the cases that petitioner cites on its side of the split have ultimately heard the interlocutory appeal and then ruled against the defendant there. So we just don't see it empirically as a large problem.
Well, what I said was, well, my volume was down. If you don't mind, consider subscribing or becoming a member or whatever, because it keeps me being able to do this.
But intuitively, the simple answer was the second answer counsel gave, your co-counsel gave, which was
send gifts or
this
anything.
is a category or cases that are factually interwound often. What was the question? What order did the government give or not give? So isn't that an easy out?
I would love to say yes, and my only hesitance is that I really do think that the case, to a large degree, depends on whether you view Yearsley as an immunity from standing the burdens of trial, an immunity from suit. Because if it is, then I have to admit, notwithstanding the court's like literal text in Coopers and Librand and all the other cases, the fact is sovereign immunity, absolute immunity, and to a certain degree qualified immunity all involved issues intertwined with the merits, and nevertheless they're deemed collateral orders.
Thank you.
So.
Anyone? Thank you, counsel. Rebuttal, Mr. Dre.
Thank you. A few quick points on rebuttal. I'd actually like to pick up where Justice Sotomayor just left off on the fact intensity red herring. Yearsley is exactly like qualified immunity. As Johnson explains, if there's a fact question, then you don't qualify for the immunity. That's exactly the same thing here. So it's contract interpretation. In this very case, the district court not only denied our motion for summary judgment, but granted the other side's on Yearsley, whether it be a defense or an immunity. So clearly, there are no open fact questions in this case. You consider the facts given in the complaint, the relevant contract, and governing regulations. No need for a fact-intensive inquiry. As for the claims about history and function, here again, this isn't loose language. The court doesn't just say immunity in passing. It talks about, since Lamar versus Brown, it explains that contractors are not liable to suit. It is clear from the court's reasoning, and Professor Volokh does a great job explaining this in his amicus brief, that this has always been an immunity from suit precisely because you're doing the government's work. And all the way through 3 circuits, the 3rd, 4th, and 5th, have all said that since 2018 in cases that we cite in the papers. As to the idea about other workarounds, like including things in the contract, please note that Dr. Joshi mentions only in-house counsel and insurance.
Oh, that's cool,
Those
John.
might be eligible under the FARs, but all the other stuff isn't. And we're not just talking about in-house counsel. I don't work in-house at GEO. Additionally, there are lots of small contractors and specialists who work as contractors for the federal government who can't contract this in, but who will have, and this gets to my last point, the initiative problem of whether or not they should continue to work for the federal government or do other better things with their time. That's why, at the end of the day, what the SG and respondents asked the court to do is to carve out a special rule, an exclusion for contractors, but based on history and function, contractors fit neatly within this court's collateral order jurisprudence. The initiative point is a good example. There are many ways in which a contractor can act, as Campbell-Ewald said, quote, in compliance with all federal directions, end quote. Think of the Taylor Energy case devising a solution for an oil spill. Contractors need to exercise their discretion without timidity and without considering lawsuits as well. So the functional analysis applies just as strongly, and Filarski takes care of this point, as the history does. So with that, the only alternative from the other side, again, is a carve-out that's idiosyncratic to contractors. There's just no reason to deny the immediate appeal to contractors that's available to the government that they serve or the government employees with whom they work side by side. Thank you.
Thank you, counsel. The case is submitted.
All right. Oh, there we go. Let's kill that. Okay. So that's everything. So like I said, there were a lot of different issues in that last case. I wasn't entirely sure where they were going to settle, whether it was going to be more about the Cohen factors and the question of the collateral order doctrine, or whether it was going to be more about the derivative sovereign immunity issue, which I think, I got to say, guys, I think they just killed derivative sovereign immunity pretty quickly. Like, they were just like, nope, this is not immunity. This is a defense. Which, what I mean, they were fast about it. So, so that was a kind of a big deal. Yeah, and as John said, collateral doctrine cases are always the exception and not the rule. So I wasn't expecting that to survive, but I was sort of, the idea that there is an immunity is it's not an unusual idea that these guys have an immunity. And the fact that they were like, no, this is not an immunity, this is a defense, that could have some pretty wide-reaching impacts, because the ability of people to bring claims against contractors in general, that could have some really wide impacts. I mean, this is not the first case. I mean, frankly, all of these cases we've heard today, and then we heard one last week, were about immunity of contractors. So this could have some wide, depending on how they write it, could have some pretty wide-ranging impacts. The counsel, the woman who was the counsel in that first case was fantastic. Just her ability, she was just cool as a cucumber. Even though I don't think she's going to win, she was great. So it's so funny having listened to so many of these now and sat through. It's not that I've never sat through them before, but I haven't paid this much attention. I usually kind of zone in and out. So court has been loosey-goosey with the language in Yarsley cases. Yeah. So I would like to see. They might make some big shifts here. I don't know. We'll see. But we're going to have to see what the opinion is. And then, guys, the biggest news that came in while we were here today is, well, actually, there were two pieces, but one that's really big is that the Davis case was denied. Cert was denied in the Davis case, which, frankly, none of us were totally expecting them to take it up, but it was pretty big news. People were very concerned about that. So, and it was particularly funny because I went to check the order sheet, and it said, and it always says it this way, but I just wasn't thinking. It said that the motion for to enter an amicus brief was denied. And I thought, oh, okay. Well, that's kind of strange. And then it said motion for amicus brief is denied and cert is denied. But I didn't read the second part at first. So I was like, okay, motion for, and then I was like, oh, wait, no, here we go. The whole case is denied, which whatever. So that's a pretty big deal. The other thing that happened while we were sitting here is that another order came out in the Rhode Island case, which is one of the 2 cases related to SNAP benefits, which I don't know if it's going to be an issue for much longer anyway, because we'll see what happens in the Senate. And I actually cut this out of my morning report this morning because I wasn't really saying anything anyway, and it was going like way over, almost like 11 minutes long. But politics, there are enough people that talk about politics. It's not really my wheelhouse. So that's kind of out. But what they said was because there were a couple of different stay orders, they kind of want the government to clarify their position and what they really want to happen moving forward. So that's essentially what they've said here. In light of the First Circuit's order partially denying the motion for a stay, and given the exigencies involved in the matter, it is ordered that by 11 a.m. on November 10th, today, the applicant shall provide the court with notice of their intention to continue pursuing a stay in district court if they indeed intend to seek a stay. So they need to submit a supplemental brief in support of the stay by 4 p.m. today, and respondents need to file a response by 8 a.m. tomorrow. So it's a lot of work. So we'll see what happens with that. The stay is on, okay, remember there were 2 cases. One case said that the $5.5 billion contingency fund needed to be released. That was the Massachusetts case. That one is fine. That one is cleared. Nobody seems to be fighting that one unless something's changed, and I haven't seen it yet, but the last thing I checked, that one's fine. The Rhode Island case said you need to open that $5.5 billion up, and you need to make up the other $4 million that are missing, that's not going to fill. Find it somewhere else. There's all these other sources lying around. You need to find one of them and fill in the other $4 billion as well. And so that case was the one the government fought. They let the 5.5, they're like, yeah, we'll open up the $5.5 billion, but we're not paying the other $4 billion. And so that's the one that they were fighting, and that was stayed on Friday. But it was a very temporary stay, and it was sort of a, like, let's just give the Court of Appeals some time to think about this kind of stay. And it was, I don't know, it felt very like, nothing about it felt substantive. Nothing in there anywhere felt like we have actually thought this through. It was all just, this is all happening a little fast. So that was the read. I don't think there is any other read to make out of the actual text of the documents. So where that $4 billion is, it's political whether or not you would bring it, but there were a bunch of options that were brought up in court that are other, I don't want to misspeak, but I know that there were other options that were different funds that are also kind of set aside as rainy day funds, some of which were big. So there are like some accounts sitting around that have a lot of money in them. I know one of the ones I heard, again, I don't want to misspeak and be conflating something, but I know I heard about a fund that had $28 billion in it. But again, I might be getting things confused. But that's basically what they were saying. They were like, find one of these other funds and move it in. But that's what the Rhode Island case said. And so the Supreme Court said this morning, if you guys still want to go through with this, you need to let us know ASAP, and you need to write a brief by 4 p.m. today, and the response brief is due by 8 a.m. tomorrow morning. So that's what we're going to see. I don't think they're going to appeal it because I think it's probably going to be pretty moot soon, one way or another. Yeah. But again, that's That's all politics. That is all peacock feathers. That's all people making decisions. And I don't mean to suggest that they are not valid and important things, but they are a different style of thinking than I usually do, and than is usually in my wheelhouse. So I have some slightly sarcastic names for things that I don't really mean to be sarcastic, because I understand that they are important, but in the back of my head they are. There's a little bit of puffery and showing off. I say peacock feathers. Poor soul's having to type away right now. Oh my gosh, can you imagine trying to write like? That's the other problem, is these briefs that have to be written in a really short period of time. Having done these before, what I find is that my first, second, fourth, and eighth drafts tend to be way longer than the draft I end up turning in, because I cram everything, every piece of information I can find in there, and then I start being like, well, this part's not necessary because I've already made this point. I don't need to make this point like 6 times. I can cut these. And so I find that those quickly drafted ones are usually way longer and way more repetitive. So that's the other thing, is that it's going to be like 95 pages long. When is Landor? Landor just finished. We just finished Landor. Or, sorry, Landor was the first one this morning. So that was at 10 o'clock this morning. So GMB says all of this is because the 2 other branches are led by people who do not have the ability to govern. Here's the thing. The 2 other branches are political branches. Political branches are by nature supposed to be, particularly the House of Representatives, which is designed in every way to be a slugfest. Like, that's how it's designed. In every way it can be designed. They made the districts as small as they could so that they would represent a really broad swath of people. There was no way that every single representative district was going to be, for example, in a city. Some of them were going to be nothing but farmland. And that was intentional. They were trying to get different groups of people in there with very different backgrounds and very different ideas. And they put them in there for only 2 years, which meant they are constantly in campaign mode. They're constantly trying to one-up each other. And they're constantly trying to, and there's so many more of them, so they're trying to push everybody else out of the way and get to the front of the room and get heard. And so it's just designed to be this like screaming slugfest all the time, as opposed to the Senate, which is kind of in many ways the opposite of that, but still politics, still a lot of showing off and getting people to notice that you're there. And so that's what politics is to an extent. Now, there may be some other things going on, but as a general rule, that is part of what's supposed to happen to some extent. So I can be a little sarcastic about it, but it is part of the design. I feel like that the design was, we're not going to be able to figure out, it's 1780 or whatever, 1787. We're not going to know what people are going to want in 250 years. So what we're going to do is try to come up with a way to come up with 2 groups of people who are going to be as different as we can think of, and then make them agree before they can do anything. And so I think that's part of, like, the Senate and the House are just going to be as different as they're just going to be at each other's throats all the time. And we're not going to let them write any laws until they agree. And so that's kind of but inherently that's going to bring some theater and going to bring some peacock feathers and some egos, and it's just going to happen. So And then, unfortunately, it also leads to things like PACs and money, and which I would much rather see somewhere in here. I have, I think it's over there, my book on the law of democracy, which I've been reading whenever I have time, about kind of what rules we have had in the past about how money is spent. And I would love to see some of those rules come back. But thank you, Oregano. As more and more money is being spent outside of the actual election system, we control it much less. How do you think about how the first case went? I think that, well, first of all, I think everybody did agree. So I've said this before, that the court tends to pick cases that are going to be a little bit extreme, so that they can set a good baseline rule. And so, for example, if they had chosen a situation where somebody's religious liberty was infringed in kind of a subtle way, where somebody wanted to pray at 5 and the prison would only wanted to pray at sunset, and the prison wouldn't, had rules so that they had to be in their cells during sunset, or something like that. Something that was a little bit more subtle, and a little bit more. I was like, well, maybe they tried a little, but they didn't try enough, or something like that. Then an answer from the court wouldn't have given us a good, solid rule, because the situation wasn't real solid. So they look for situations like this, where there is no question that somebody's religious rights were, like, not just trampled, but I mean trampled. And I think, we were sort of surprised when somebody said, oh gosh, they just said, I forget what word, egregious or something like that, because it was egregious what they did here. This guy walked in, he knew in advance that this was going to be a problem. This was the third jail he'd been to. This was only a 5-month sentence. I actually never found, I looked through the lower court opinion, and they never said what he was actually in for, but it was only 5 months, so I'm guessing it was, I don't know, I have a couple of guesses, but it probably wasn't something too big. But he was moved 3 times during that 5 months. And the first 2 jails, nothing went wrong. As a matter of fact, the second jail, I think they said, one of the 2, but I think it was the second one, had a policy in place that did not allow dreadlocks. And because of his particular situation, the jail voluntarily changed their rules and said, for his situation, we will voluntarily change our rules and allow it, because we understand that this is a truly held religious practice, and we don't want to step on that. That seems like a pretty reasonable time to not do this. And he gets to the third place, and he's expecting a little trouble. So he walks in there with paperwork from the first 2 jails explaining the religious accommodation that they had given him on paper, and a copy of a Fifth Circuit case specifically about a Rastafarian man who had his, and about his ability to keep his dreadlocks. The Fifth Circuit had already ruled on this, and he brought a paper copy of that court case with him. Walked in the door, and he's like, I knew this was going to happen, so I came in and I started explaining, hey, I know that you're going to want to cut these, but this is my situation. I just want to let you know ahead of time, whatever. And the guy, when he walked in, the guard, when he walked in, took those pieces of paper, threw them in the garbage, called the warden. The warden came out and said, I need you to give me the ruling from your sentencing officer where it says that you have been given religious accommodations for your hair. Where is that ruling? And he said, well, there was no ruling that said that specifically. And he said, all right then. And they dragged him into the other room, held him down in a chair, handcuffed him to the chair, and shaved his head. the story could not be more egregious. This is such an extreme situation. There is no question that he had very closely held religious beliefs. As a matter of fact, I went ahead, hopefully this won't take long, because I wanted to know Numbers 5, nope, too far, because I wanted to see what the thing actually said. Numbers 5:6. So what he is responding to, Numbers 5:6 says, all the days of their Nazirite vow, no razor shall come upon the head until the time is completed from which they separate themselves to the Lord. They shall be holy, and they shall let the locks of the head grow long. And so that's what he was doing. I mean, this is straight out of the Old Bible, the Old Testament. And so this is really, really well documented religious belief. This gives the court an opportunity to say, in the most extreme situation, how do we handle this? And so they're going to set a rule based on the most extreme situation. And then from there, the lower courts can figure out what happens if the situation is a little bit less extreme. And that's pretty much what we're going to figure out now. And the question's going to be, Samson is a very good example. And the questions are going to be about, because there is a particular rule, and I missed a couple of points here, but let me make sure I got this right. There's a federal law. Because remember, there's a lot of issues with federalism and what the federal government's allowed to tell states to do. But I think that the way this happens is that the federal law requires that if the states want money, they have to agree to these rules. I think that's the deal, and I think that's what they were talking about. And the rules say, and the rule is called the, it's like it's a really long acronym, like the religious something, 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 because it's like 6 letters long. And this was a violation of that. But that rule did not have a private right of action, a right where if your rights are violated, you can bring a private right of a civil action for money, for monetary damages. And it wasn't RIPLA, it was something, but well, maybe it was RIPLA, but I don't think it was. And I'm trying to see where my folders fell. Oh, there we go. Hold on. This is why I color code my folders so I can find them relatively fast. And no, I'm still not going to be able to. Oh, it's Reluipa. So you were close, but it's, yeah, there we go. Reluipa. The Religious Land Use and Institutionalized Persons Act. So the question is whether it provides for money damages against officials sued in their individual capacities. And the problem was that the Fifth Circuit had another case where they asked exactly this question. But the situation probably wasn't so extreme. It wasn't somebody who was dragged out and held down and had his head shaved in violation of his, it was probably something more like, at 5 o'clock, we can't quite do that. Could you do 6 o'clock? And he said that was a violation of my, something more subtle. And so in that case, the Fifth Circuit had said, no, we can't allow you to get monetary damages. And so the Fifth Circuit, when this came back up, said, we've already decided this. And even though we think this is terrible, we have to stick with our other decision. And this was bringing it before the Supreme Court to see if maybe they should overrule that. And I think that they will overrule it. I think everybody agreed that that they will overrule it. So that's a lot of talking to get to the end there. But I think that yeah. But this gives them. This is why the I always say. Well, I stole this from somebody. I didn't make this up. But the court takes cases for their reasons, not yours. 50 people can bring nearly the same case, and the court will reject 49 of them and take the 50th one because the facts are right. You know, if 49 people brought this same case, but the religious right that was infringed just wasn't extreme enough, they want a good extreme case so that they can make a good rule out of it. And so they can let, because part of what they're doing is letting the lower courts know how to rule in the future. And so they want to make sure it's a good, solid case. It's not going to be wishy-washy at the end. Does overrule mean more? Overrule would mean that people whose religious freedom is infringed would be able to sue the guards. That's what it would mean. Individually, they would be able to go after a monetary damages. Sorry, it would mean that if you had a case this extreme, you would be able to get monetary damages. From there, we allow the lower courts to hash out the lesser cases. But the Supreme Court's saying that if you are all the way at this end, if things are this crazy, then you are able to go and get individual monetary damages. And then from there, we'll work out the details of the lesser cases and the more confusing cases. And that's where you end up with those circuit splits, because, you know, a less obvious case will happen in the Ninth Circuit and another less obvious case will happen in the Fifth Circuit. Maybe they'll go two different ways, and then, yeah. Yes, constitutional stare decisis is weaker than statutory, which is definitely the way it should be, because the Constitution is way harder to change. And anytime we get a reading on the statute, the court interprets a piece of statute, Congress has the opportunity to come in and change it if they don't like that reading. And it's much easier for them to change that statute than it is for them to create a new constitutional amendment to overrule the court. Transgender people in women's sports, you know, I was kind of curious about that myself. Why? But I will say, here's one thing that I recognized, and I'm going to go back and listen to that part again. That was something that I noted that I want to go back and listen to again, because, I've just put on my Amazon wish list, actually, a copy of, if anybody wants to get it for me, of Justice Barrett's book, because I want to read her. She's going to be on this court for a long time, and I would really like to get a better sense of how she thinks she interprets. But I noticed a little bit. I know Amazon sucks, but it is the best way to. It's a good way for anyway. But I noticed that her presentation of the situation that she was putting forth was very the word I'm trying to use is respectful or deferential. I don't know another word to say it, but signed copies at SCOTUS? Oh, all right. I can't think of the way that she said it, I felt, and was, let's just say that I feel like if Justice Alito had said the same phrase, it would have sounded a little different. I felt like she phrased it in a way that was very considerate to transgender people. I think that it felt like a very... thoughtful, maybe. I don't know. I need to go back and look at it again. But it felt like, and I think that is telling, at least about her personal approach. Maybe not. I don't know. But I need to go back and listen to that again. Am I on LinkedIn? That's a different me. So the cases today were Landor v. Louisiana Department of Corrections and Geo Group v. Menocal. So I don't think Barrett is going to ever move to the left. I do think Barrett is going to be known for her interpretational style more than her political or partisan, I have to avoid the word political, than her partisan takes at the end. I think that is how she's going to be known at the end. I think she is going to be known for her interpretational style, which I think is going to be, I've already noticed, very, she really seems to go to, the equity well, the roots of equity and that sort of thing, which is what I love. Oh, what case were we discussing about transit? She just mentioned it as an example in Landor. Landor. She just mentioned it as an example in Landor. It wasn't part of the case. But I think that's where we're gonna end. She's gonna end up being known. And this is something that happens with a lot of Supreme Court justices. They get put on the bench for their in the first year or two, they're very, very partisan, and then they start to realize nobody can touch me. I don't have to answer to somebody, but it takes them a while to realize that. And they start to kind of flex a little bit and stretch and realize that they can get away with stuff and nobody can hurt them anymore. And that's why the Supreme Court they're not removable, they're not answerable, because over time they can flex and figure stuff out without worrying about whether or not their decisions are popular. Yeah, I think you're right, Nerdy IT. I couldn't remember. It's one of the problems, guys, is that, well, and I think this will get better over time as I get better with this system that I'm still messing with. But usually I'm doing a lot of stuff at once. And so sometimes I sort of zone in and zone out for here and there. And so all of a sudden I'll be like, wait, what just happened? So I usually go back and re-listen, sometimes a few times. Thomas and Alito. Well, yeah. I will say I like Thomas's writing. I know. And I hope, by the way, guys, that I'm getting closer to getting this system to work in a really cool way. It still does. If anybody can do I was really excited about the idea. Oh, he moved again. To do, because so I think I told you that I got knocked off of the creator, I can't even say it, rewards program. So now I'm only like gifts and things are like the only way I have any income anymore. And so I found this thing where I could make it so if you bought that thing, it would switch over to Obi, and I was really excited about that. But then it wasn't quite 100% working. Anyway, I'm gonna keep playing with stuff like that. Okay, so by the way, so there is no there are no cases tomorrow. There's nothing tomorrow. I'm probably not even going to do I may not even do a thing tomorrow. Thank you. Because it's, did they? No. Because tomorrow is, I think is it Veterans Day? I think the 11th. I gotta say, like, Thomas's writing style is so clear. Oh my gosh, you guys. At some point, I am going to, I've wanted for a long time to do some writing about how to read court cases and to teach people how to read court cases, and it will almost definitely be a Justice Thomas case that I use, because they are some of the clearest court cases, the clearest opinions that I've seen. They just follow the structure so cleanly. So, yeah, the interpretation is not always right. But you can see it so beautifully when he's like, he'll be like 1 plus 1 plus 1 equals 6. I mean, it's just, it's so perfect. You can see exactly where he makes the mistake because it's written so perfectly clearly. Whereas so many other people will be like, you know, the square root of this divided by that over, you know, and all kinds of weird stuff. So you can't really follow what's happening. And then the number's wrong, but you really don't know why. So I give him some credit for that. Anyway. Did he do a casa? Writings of Breyer. Oregano, I'm trying to think of a way to get it to me, but oh, he wrote, that's right. Oh, God. Feels like years ago. I'll figure that out later. Let me see. What else do I have to say? Oh, okay. So there's no hearing on Tuesday. So there will be, looks like there's 3 cases on Wednesday, but I'm guessing 2 of them might be related. That's usually the way that works. Oh, that'll work. Yes, please. Thank you. Thank you. Good idea. I may do a live tomorrow since I probably won't do a morning report tomorrow because I will. Oh, sweet. All right. Because I will just wrestle with trying to get this machine working properly because tomorrow, Wednesday will be the last oral argument. Is that right? That can't be right. Yeah, it looks like it. It's the last Supreme Court oral argument. I have another, there's a JGG argument the next week, but I can't do that one live. So this is my last chance in November to do a really good one. So hopefully I will have this working at least a little better by then. And one of the things I really wanted to have for you guys today that I didn't get was, I had it working, and then this morning I ran out of time to like reset it. Is to have a little bug in the corner that would tell you who was speaking. And I was so excited about it, and then it just didn't work. But, okay. All right, I'll check. All right. But for now, I am off, and thank you all for joining me. And I will see you all on Wednesday. All right? Bye, everybody. Thanks a lot.